me just clarify one thing. Sir, do I know you?
No, ma'am.
He's been in front of you many of times, and I have
Hold
record
on,
to show that.
ma'am, hold
Yes.
on just one moment. You made an allegation, so I want to clarify that for the record, because I don't know if I know
Here we
Mr.
go.
Branson.
Yes.
Sir, have you been
Already.
in front of the court before?
No, ma'am. Yes, I'm gonna say 20-some years ago.
So it would not have been in front of me.
No.
It was not in front of me.
Yeah,
When,
threshold.
when you were a member of the city council.
Was I a member of the city council?
You signed off papers on him to do side work, and he actually submitted that, and you were the one who signed off for him to do property work on his house.
Property work
Yes, he actually submitted that in his own evidence.
that I signed off for him to do
Yes.
maintenance on his.
Yes, Your Honor. I have copies of the paperwork.
Okay, let me take a look at that paperwork, because, I mean, if I'm.
Ah, you
if I-
son of a bitch.
And Mr. Branson, how do you know my court officer?
A longtime family friend from years ago. I haven't had any
Let's see,
relation with
Santa
him for
right
at least
there.
15.
Okay, so you know who each other, you know who each one is, but
This
you
is,
haven't had any
apparently
communication
pretty
the last
wild.
15 years?
No, easy, yeah, no.
If you go to his filing that he submitted himself. Okay,
Ma'am,
I'm just saying.
please stop, just one moment, okay? All right.
It gets crazy.
Okay, so ma'am, this is a zoning board of appeals and adjustment. I do not sit on this board. This is my husband who sits on this board.
Okay.
And I can 100% tell you that we do not discuss anything
Okay.
that he does here. This is definitely not me.
Okay.
I've never sat on a board, a zoning and appeals board.
Okay.
And this is from 2009, so I can tell you 100% that whatever this would have been, I have no idea. And I will also state that member DeSanto abstained. There were two
It's
members
90
that,
degrees.
one that
I'm just
abstained,
not going outside.
one that was absent. So I don't know why he would have abstained, I have no idea, but I can tell you that I did not sign off on anything.
Your Honor, I'm just going off of what he used to tell me, and in the text messages I have, where he said I have the judge in my back pocket.
Okay,
Your Honor, again,
let me,
that's simply not true.
hold on, let me clarify something. Sir, do you know my husband?
Personally, no.
Okay, so ma'am, I will tell you right now, I do not know Mr. Branson.
Okay,
And
yes, okay.
so do you have any issues with this court continuing?
Not at this moment.
Okay, well, I would say that, that if something different comes up and it's shown that somehow I know Mr. Branson or somehow, then perhaps we can revisit it, but moving on, but at this point, I find that I can be
Okay.
unbiased.
Thank you.
And I don't know Mr. Branson, and Mr. Branson knows, my court officer, but they haven't had contact for at least 15 years.
Thank you, Your Honor.
Video game.
I appreciate that, Your Honor, for you being honest.
Okay, so let me, and I will also say too, in smaller towns, right, you're gonna have that cross.
What's the problem
That
here?
crossing and such, but, you know, as I learned in new judge
Oh.
school, that judges are elected to serve, and
You're,
they have to sit and reside in the community that they serve, and so sometimes there's going to be people that they know, so it all just has to be disclosed on the
yes.
record.
may I just be frank a moment? I'm just scared because in my text messages,
Nice
since I've lived there, he has said
AC.
he
Oh
has
my
police
God, it
officers
feels
in his
good.
pocket. He has a judge in his pocket. That is
Okay,
just where
let me see that, let me see the
I
text
have-
message you're referencing, please.
No, I will find it. I have 2 full boxes that I've printed out.
Okay, I'd like to see that, I'd like to see the
It will-
message that's.
I will have to find them, but.
Okay, I'll give you a moment, go ahead.
It's so fucking hot. It is so hot. So right now,
These, I can pull them up off my phone too, if it's not in the ones I printed off here, it might be in the ones that I gave you.
Okay, you said gave me, you mean
Yes.
in your filing, that, the motion?
Yeah, I didn't print off the entire text chain, but the police also have them too, because we found out he wasn't a police officer. That he's never
Well,
been a
just
police officer.
starting
that he's
out,
told me.
but-
But we could continue, that's not, neither here nor there, I
Actually,
said.
She's
no, Your Honor,
saying
she said she just represented under oath to the court. She made a
that,
statement, an affirmative statement about.
I just wish she
You
could.
can't, ma'am, you can't interrupt.
Thank
Okay,
you.
just one moment.
At this point in time, Your Honor, she's sworn under oath, and you've asked her for those documents, now she's backing away from it.
Oh, no, no, we're not stopping, I need those, I wanna see.
Okay,
that.
I'm trying to find them right.
yeah, she's claiming that her husband is on a board or something, and her husband's paying people off, and it's just not true, obviously. And yeah, she's crazy. So come on, you fucker. Yeah, that kind of looks weird. All right, I'm just gonna keep it there.
Right now, I have stage 4 cancer and I had a surgery, Your Honor. I'm saying if I don't have them here, then they're on my phone.
Okay,
I would like time. And if I can't
I'm
find,
giving you some time right now to look for those.
I have over 1,000 pages here. I'm just
Okay,
saying,
then do you have your phone with you?
yes.
Okay, pull up your phone, and then on your text messages, when you pull it
May I
up,
sit down a moment? while I do this?
absolutely,
Thank
you can do a
Yes,
search,
absolutely.
absolutely.
Thank you.
You can do a search for the name Pocket, or search
I don't
for
know how
Pocket.
to do all that, ma'am. I have a 2010, an iPhone 10.
Actually, you can just go to your text messages, you can hit search, and you can just type in a
Hey,
word,
what am
and it'll
I?
pull up all the text messages that have that word in
The
it.
Looking
police
for
are going
weapons.
through my phone because he has gotten into my phone, Your Honor. The police have, I have a police case against him right
Hold on,
now.
yeah, right now I'm not worried about that, I wanna know what that says.
He's been editing my phone, Your Honor, is what I'm trying to tell you.
Ma'am, please just take a minute, or 2, or 5, and look for that, please.
I will. But I'm just saying, I was
I
thinking
don't,
a
no,
motion to
with no,
dismiss.
with no more commentary.
Shit.
Motion to dismiss.
Hey, buddy.
I said no more commentary. I haven't gotten that far yet. You've made an allegation, and I want to see what that message is. And did you do a search?
I am looking right now. It won't let me do a search. So I have to look through the entire text feed.
Jesus.
Do you know what month it was that he stated that to you?
When I first moved in,
Which was when?
back in June.
Okay, so
That's
just
why
going
I-
back to June?
Yeah, that's why I've been terrified living there.
Okay, ma'am, I didn't ask for all that. I'm just asking if you went back to June.
Yes, I'm all the way at the beginning of the text feed. That's why I said we can move on. I'm fine.
No, ma'am, we're not moving on until I see that. Did you find it yet, ma'am?
No, ma'am,
Yeah, especially if
I'm
you're
still
gonna
looking at
claim
all
that the
his
judges
comments he was sending me.
paid off. She's not just gonna
Yeah,
move on.
Yeah, there's honestly gonna be a moment.
Let me see if I can
honestly
remember
not
any
trying to lie
like
to this court.
really crazy.
It was
Ma'am,
said to me.
You made an allegation, and it's on the record, and so I would like
It is on the record.
to.
Yeah, she's
Ma'am,
gotta get.
ma'am,
She's gotta go
ma'am,
through that
I'm just
shit,
letting
man.
you know right now. I'm not gonna have the continued interruptions. If you made the comment on the record, the allegation on the record, so I want to address that on the record. That is what I'm saying. Because I can assure you that in the event anything like that was said, this court's not in the back pocket of anybody. I don't even know the plaintiff, as was already established. Okay, well, while you're still looking for that, I'm going to ask a few questions. Ma'am, you have been residing in the home since June, correct?
Correct, Your Honor.
Okay. And what is the monthly rental amount?
$1,500.
And counsel, what is the tribal issue that we have?
Your Honor, there is a trial issue. There was a $500 balance in
Oh,
November.
November, okay, I'm
Yes,
sorry.
ma'am.
$500 partial paid with a $1,000 balance in November.
That's
You said
correct.
December and January and February have not been paid?
Had not been paid, but I verified earlier today, per the court's order, she had made $5,500 deposit into the escrow.
So then the only thing that you were looking for was the rent that was not paid.
Correct.
And so,
And utilities.
And utilities.
well, hold on, that's not on the complaint. On the complaint, it says $625, and it says late fees. So, and you're withdrawing your late fees.
Correct.
Okay, so it doesn't have any other allegation in here other than the unpaid rent.
That's correct, Your Honor. We will withdraw the allegations regarding the utilities. So the only thing we're seeking, in fact, are the rent, is the rent.
Okay, now, December and $1,500, so it's $5,500, so $5,500 is due and owing, and Ms. Collins has deposited $5,500 in escrow.
Correct.
So, once your client gets that, rent's paid in full.
That's correct.
Okay, so Ms. Collins, you you filed 2 motions. So I was actually asking those questions because I wanted to know, I wanted us all to be on the same page with what
I
the
miss
issues
up
are.
here.
So you
Oh,
filed
hell.
a motion to dismiss and an amended motion to dismiss, and then you've also filed the motion to suppress the exhibit list.
Get to the
Now,
good stuff.
I will note that 2-1,
Yes.
and you moved on to the 2-2-2-3. So seems to be the 2 pages that she's referencing. She's referencing, okay, so I'm going to presume then, is that when did you contact the engineering department to schedule the January date?
I've been in contact since December.
Put your hand up.
With Kelly from engineering, and I knew what it was is once we were out of there and I rented, it was like, I had made a phone call over there and said, do I need a certificate of occupancy? There was a miscommunication, and she goes, no, you're 22, 23, and the 22, 21, they got them crossed over. She goes, no, you don't need a CFO. Well, later on, you do. I immediately started contacting some of those.
Okay, so my question is, there's a whole bunch of stuff for 22, 23 on here. Have you made those changes?
I don't know what inspection is, because it has had previous inspections.
Right, it has been from 2015, 2019. Here's what I have
Where
to do
the
right
fuck
now.
is
Right now I have to, for safety purposes, I have to handle this in custody right now. So what I'm going to do is I'm going to order that you all go out into the lobby. And let me just tell you where I'm heading with this. You've indicated you want to relocate. Mr. Branson has offered to guarantee, stop telling me,
Yeah,
as
this is
Garen
boring.
has offered to
I know she
guarantee.
flips out, but whatever. Let's see. I didn't know I wasn't subscribed to him. Let's go with... Oh, this is a good one. This is a good... I like this girl. Not very smart.
All right, let's take up Miss Green. And how do you
In a
pronounce
weird
your
way,
first
I feel
name?
bad
Is it
for her.
Karis? Cirrus?
It's
Let's see.
Karis.
Okay.
She
We
comes
are
off
on the
it, you know.
record in
You gotta feel
2022
sorry
CR
for me.
136, State of Kansas
She
versus
plays that
Karis.
card.
Is it Juana?
A lot.
Juno?
Juno.
Juno, like the, okay, Juno
Yeah.
Green. Karis Juno Green. Miss Jill Gillette,
And she
County
does it
Attorney
to
for
herself.
the state. Miss Green in person and pro se.
What? I don't know how criminals just don't understand. Like, just be honest.
Okay, does Miss
You're gonna
Green
get.
still have an
They're
outstanding
gonna figure it
warrant?
out eventually.
Where are you, Miss Green?
Yes, she
I'm
does, Your Honor.
Okay, where are you, Miss Green?
In Alaska.
Do you know you failed to come to court?
Yes, I do.
Why did you fail to come to court?
Well, honestly, I got mixed up on my days, and when I looked at when I was looking, I looked down on my phone and I saw that it was the 13th, and I was like, oh my gosh, it's the 13th, and it was
Oh my
like
gosh.
hours has passed because I forgot about the time difference too, and so I called the person I'm supposed to check in with, like every
You hear
week,
this-
but she didn't answer. I'm assuming because it was probably too late, and I just, yeah.
Okay, so on August 22nd, you posted a
You hear everything she
$7,500
said?
bond.
All
with
of it
us.
is a lie.
Who's
All of it.
Cynthia Miller?
That's my mom.
Okay, you just cost her $7,500 by not coming to court. She's gonna have to lose that.
Yeah, you see that
There's
face?
no way that like.
And that was a cash bond,
No,
it looks
you
like.
didn't show up to court, you moron.
Paying party authorizing
What do you
the
think
money
bail
to be paid to the
means?
cost of the case.
Yeah, you just cost your mother $7 grand.
Then post another bond on September 13th.
Congrats. Yeah, she
Look
knows
at
she's
that.
fucked.
No, that's
She'll
probably the
never get a
same one.
favor from her again.
Yeah, you were supposed to be here
Your
September
pouty face is
13th,
not
and
gonna help you
didn't. So,
either.
same bond, but that's for the forfeiture of it.
Yeah, she knows she's fucked.
And then you had a failure to appear warrant.
My
And
mom
now
would
we're
rip me
looking at
apart.
motion. 5 days ago, there was supposed to be a motion for judgment on bond. Was that heard and granted, Ms. Gillette?
November, it's scheduled for November 18th at 1. The forfeiture is scheduled for November. That was the date that was
Yeah.
given to us.
The reason why she does her little pouty face is because
Do you get the impression
It's
that
gotten
maybe
her
it was
far.
a big deal to forget court, Ms. Green?
it's gotten her out of a lot of trouble. And
Well,
they're
you haven't
too-
had your
they're at
reading
the
of your
point
rights and
right now where
charges since you
it doesn't
failed to
work
come to
anymore.
court
Put it that
when you
way.
were supposed to. So let's go over the charge. You've got a
'Cause
pretty
she
big
screwed
charge
herself.
here. It's
She thinks she can keep doing it.
You're accused of unlawful possession of the controlled substance.
Hi, buddy.
Methamphetamine. That is a level 5 drug felony. If you are to be convicted of that, depending on what your criminal history is, you could serve at least 10 months,
Yes.
up to 42 months in the Kansas Department of Corrections, which we commonly call prison. Okay? Up to 42 months in prison.
Whoa.
Is your hair more important than your prison sentence?
No, she's trying to look good. So she
Okay,
can try and
because
get out
you
of
seem like
whatever.
you're distracted with your hair, and I would expect you to be attuned to this.
No, she has it down by now.
That you're looking at of
How
10
she
to
gets out of
42
trouble.
months. You're also looking at a potential fine up to $100,000 if convicted. In count two, you're accused of unlawfully possessing drug
What a
paraphernalia
moron.
in the form of a glass vial, hollow pens, syringes, rolling papers, and a glass smoking pipe.
There's a weekend
Possessed
for you.
with the intent to either contain, conceal, inject, ingest, inhale, or otherwise introduce a controlled substance into the human body. This is a Class B non-person misdemeanor, which means after you get through with your prison sentence, you could be ordered to come back to the Greenwood County Jail and serve another 6 months and pay another
Dang.
fine up to $1,000. So do you
This-
have any
I promise
questions
you, the
about what they're
ending in
saying
this
you
is
did
so-
and what
so-
the possible
so
penalties
good.
are that I've gone over with you?
Oh, good.
Do you intend to hire an attorney or apply for court appointed?
Applied for court appointed.
Do you work?
It's a couple.
Yeah, I've been actively looking for a job though.
When did you
In a
start
while.
actively looking for a job?
When I got out of jail.
And when was that? September? August. It was August, wasn't it?
It was August 27th, I believe,
Uh-oh.
or 28th.
Okay. And you went straight back to Alaska?
Yeah,
Are you living with someone there?
yeah,
Who?
my mom.
Oh, really?
Bond, well, never mind. Okay. So your mom is supporting you. How old are you?
24.
What's the highest level of education you have?
Some college.
How much?
First semester.
Did you pay for that out of your own pocket?
I applied for the FAFSA grants.
So you got federal grants to go to college,
Yeah.
and then you dropped out after the first semester?
No, I'm still going.
Oh, okay.
You just,
Yeah.
But you didn't start until you were 24?
I was 23 at the time.
And what
You're all those lies.
Uh-huh. I'm studying
It's not gonna
criminal
get you
justice.
anywhere.
Okay. All right, I will appoint an attorney. Missy, do you know who that will be?
No, I do not.
All right, you call back here Friday to my office to find out who your attorney is.
May I get
Busy.
the number, please?
Yeah, Missy, can you give her the number to call, please? Call Friday, find out who your attorney is. Then call that attorney.
Okay.
For me, it's very annoying to appoint an attorney and then the person doesn't even have the ambition to call. So be sure and call the attorney and be ready to go for your next court date. And Missy, when is her court date?
November 18th at 1:30.
November 18th at 1:30. Be back here with your attorney. Now, we have to decide what to do about that warrant. I can make you turn yourself in there in Alaska, but I don't want to have
Yep,
to make the
see
sheriff
that worried
pay to
face?
go get you. Maybe they want to go there. It's a lovely place, I'm sure, this time of year, but Ms. Gillette, what's your thought on that? On the warrant?
If the warrant's lifted, I would like her to call court services each week so that we know where she is.
Do you have a
Yeah, she thinks
position on
she's-
whether it's lifted
She's
or
getting
not?
off.
If it's, I'm fine being lifted if she calls court services every week.
Fucking.
Under
holy
Sheriff
face.
Cox,
Get the
does
hell
your
outta
office
here.
take a position on
24
what to do
years
about
old.
that warrant?
Yes, Your Honor, I do.
Okay,
I am fine with you and Miss Gillette lifting that warrant, but I would like to see
Proof.
a $50,000 OR bond where she turns herself into local law enforcement, and that way we know exactly where she is. Because I have information that she's actually in
Watch your
Pueblo,
face.
Colorado, not Alaska.
Pueblo?
Yes.
No.
No. That was convincing.
who was the gentleman walking around behind you in the picture a while ago?
Oh, that's my friend.
Well, who is he?
His name's Dale.
Dale what?
Dale Whitman.
Dale Whitman, how do you spell that?
One second.
Well, just have him come on up here.
Yeah, once you start staying at other people's houses, you're including them, and if they
Good
don't break the
afternoon, Your
law,
Honor.
they're not. They
Good
don't want
afternoon.
anything
Can
to
you
do
put
with
your
it.
Face in this camera, please.
Oh, I'm sorry. I didn't realize that was on video. I apologize for my appearance.
All right, your name is Dale Whitman, is that right?
That is incorrect. It's AM.
A.M. And how are you connected or related to this young lady?
I'm a friend, and I specifically met her friend Aaron, who was involved in the same case.
Okay. And where do you live?
I live in Green Mountain Falls, Colorado.
Oof.
And you're at home right now?
I am.
What's your address?
My address. New. Green Mountain Falls, Colorado, 80819.
All right, thank you, sir.
Got
You
caught
said, what was the name
lying.
of the town in Colorado again? Green Mountain?
Green Mountain Falls. Very
Green
small
Mountain.
town, population about approximately 2,000.
All right, thank you, sir.
Thank you, ma'am.
Welcome. Ms. Green,
Yes.
you just lied to me.
Whoop.
You said you weren't in Colorado. Well, what'd you say, officer? New Mexico? But you told me you were in Alaska. Remember when this hearing started and you said you were in Alaska?
Oh.
Why'd you lie to me?
Huh? Huh? Huh?
You realize you put me in a position where I can't trust anything you tell me now. So tell me why you lied. What was the point of that?
I just don't. Because I forgot to tell the person I call into weekly that
My God.
I decided to go back to Colorado before my court date.
Jesus Christ.
But I was thinking about, or my mom was gonna get me a plane ticket back to Alaska.
Your mom doesn't happen to be there, does she?
Well,
Huh?
you're already over
Does your
7
mom happen
grand.
to be in the house with you there?
Oh no. But I can give you her information and stuff.
No, I've got some information on that bond that you're costing me. Well, I was ready
Yeah,
to
about
set
that.
aside your warrant, but then you lied and said you were in
Damn.
Alaska, and I find out you're in Colorado. And Undersheriff, did you
See?
say you had information that she'd been in New Mexico? Did I
No,
All you gotta
I
do
said
is tell the
Colorado,
truth.
Your Honor.
Okay.
Initially, it was Pueblo.
By the way, watch this guy right here. When, has he already done it? Okay, yeah, just watch him closely.
Oh, okay. Pueblo is what I was thinking of, and that's not New Mexico. All right. Does that change anybody's recommendations since she flat lied?
I think the warrant should stand, Your Honor.
Yeah, that's what I'm thinking too. We're gonna leave that warrant out for you.
Dang. See? All you had to do is not lie.
I'll
See?
leave your court date.
Are you watching him? He's on the phone, right? I wonder what he could be doing.
You can still call back and find out who your attorney is, but if you're smart, you'll go down to your local sheriff and turn yourself in on your warrant.
You don't fuck with that. That judge is super nice, but if you lie to her, it's done. It's over with. She does
Well, I
not
would have
like
you
being
if
lied
you
to.
hadn't lied to me.
I'm so sorry.
But like I said, I can't believe anything you tell me now. I mean, you just sat there and looked at the camera and just flat lied.
I'm sorry.
You know you're not
I've
lying.
just really been stressed out. My uncle, who was like my best friend, just passed away while I was in jail. That's why we were going out to Georgia, is because he passed away.
Where were you
So that
going?
means you should lie?
To Savannah, Georgia.
Weren't you going the wrong direction from Kansas?
I don't believe so.
You were going to Savannah, Georgia, because your uncle just passed. You were in Kansas, and you ended up in Colorado. Is that right?
No, I was before I got arrested. I was going to Savannah, Georgia. I was just following the maps, like where the maps told me to go.
But you ended up in Colorado. Those are
No,
opposite directions.
before I went back to Colorado, before I got out of jail. Before I even got arrested, I was heading to Savannah, Georgia, because my uncle was on his deathbed.
Oh,
It was
that
really,
sucks.
we were pretty close, and it was my mom's last living family member, because my grandma and my aunt had passed away like a couple months before that. And so it's been really hard.
Yeah, it don't
And
matter.
your mom's in what
You
state
lied.
right now?
She's in Palmer, Alaska.
And she came all the way to Kansas in September to post your cash bond? Is that right?
She was in Savannah, Georgia, when I called her, praying. Like, seeing her brother in the hospital, dealing with that.
Wow. And you just cost her $7 grand.
Came to Kansas to bail me out.
So she was in Savannah, Georgia, dealing with her brother on death's door, passing away, and then
And
she
you
had to drop
skipped.
everything there and come to Kansas and put up $7,500 cash to get you out of jail. And then you failed to come to court for the day you made bond. And now you have lied today and told me you were in Alaska, when in fact you are in Colorado. Is that correct?
Nice.
And you're accused of having possessed methamphetamine and drug paraphernalia.
Probably
How in
wondering
the
why.
world did Greenwood
Why is the
County end
judge
up
just
having
sitting there
to
talking to
deal
her?
with you? How did you end up here? You're on the way
Just
to Georgia,
chatting with her.
and you got what? Stopped for traffic?
Yeah, pulled over, I guess for speeding. I believe that's what the original thing was for, and the person driving didn't stop. They just kept going.
Are you related to the person driving? Who were you with?
My ex-boyfriend,
Okay, what's his name?
Aaron Berg.
Aaron Berg, I think he's on the docket too. And
Surprise there.
is that a tattoo or a scar, or what is that above your eyebrow there?
It's just like chatting
It's a
with her.
tattoo.
What's it say?
Cilicia.
What does that mean?
It's the delusion of seeing things more beautiful than they really are.
Well, I was curious because I saw that, I think I was in the same place on another girl earlier today. Do you know anybody else in this area that has that on?
No.
Okay. Well, how far are you from the nearest law enforcement office, if you know?
Like 45 minutes to an hour, maybe.
Do you
In
normally?
downtown
Sheriff's
Colorado
shaking his head.
Springs.
Okay, and do you normally stay at this gentleman's house? Is this where you're staying right now? You're
Just frequently, like,
well, where are you gonna be between now and your next court date?
here and or in Manitou Springs.
And who do you know in Manitou Springs?
Suzanne.
What's Suzanne's last name?
I don't know.
Family, friend, acquaintance?
A friend.
Well, I'm gonna have you sit there for a little bit while I think about what I'm gonna do with you, okay? All right.
She thinks
So
she
we're gonna
might
take
be
a
getting
recess
off,
from
but
Miss Green's case. We're gonna take up Van
that's a big
Doty.
no.
Missy, could you put under Sheriff Cox and me in a breakout room, and Miss Gillette?
Yes.
Thank you. Are you still with me, Miss Green? Okay,
Yeah.
all right. And you told me, did you tell me you're gonna turn yourself in or not?
Oh, I mean, yeah. My friend wanted to, if it was okay, talk to the courts.
All right,
Okay. Yeah.
Good afternoon again, Your Honor.
yes, sir.
Again, I apologize for the way I look. I've been home here painting windows.
You're fine.
I haven't heard all of the proceedings here, but I did hear the part, everything from the time I first spoke to you and after that. And if it would help the court at all, I would be willing to guarantee that you would stay here for at least the next 3 or 4 days. I'm a renter. It's a large house, 8-bedroom house, so there's plenty of room for her. But when my landlord, who's out of town, if she okays it when she gets back, Miss Green could stay here for an even extended period of time. But I can't promise that right now. But I can promise the court that I can guarantee her whereabouts, at least for the near future.
Okay, so you live in an 8-bedroom house?
I do. I rent an 8-bedroom house, but I also do a lot of maintenance here. I'm painting the windows right now as part of my rent. It's a beautiful house, but it needs some work, and that's what I'm doing.
Where'd you say your address was?
Green Mountain Falls, Colorado, 80819.
Okay, you lost me now. And is there any kind, so apparently there's not an apartment number to it if it's a house?
No apartment number.
Okay, Foster Avenue.
Correct.
And the name again, I'm sorry, was it Green?
That's fine. Green Mountain Falls. It's a gorgeous town here, located just 15 miles west of Colorado Springs.
Excuse me, sir. Did you say
Did.
okay?
Okay, and what county are you in?
El Paso.
El Paso. And what is your connection to this young lady? She was kind of vague on that.
Yeah, there's no real connection, I guess. I first met her friend, the one who's also involved in this case. His name is Aaron, and met Miss Green through that, and just kind of befriended them a little bit, and would talk to them, see them around town from time to time, things like that. And that's about the entire connection. It hasn't gone on very long, but it's been. I feel I know her well enough that I could guarantee the court of her whereabouts, and if there is any problem, you can bet I'll contact you, because I'm not going to jeopardize my freedom or anything else by.
Yeah,
So
no
did you
shit.
hear us talking about how her mother posted a $7,500 cash bond and she skipped out on that?
I did.
So her mom's gonna lose $7,500, but you're still feeling confident enough you can keep her around?
I think I can,
Right.
Your Honor. And if I can't, you'll be the first one I call.
And you know that she's looking at some serious charges here.
Yes, I understand. But
Okay.
to be honest, I don't see how that affects me in any way. As long as
Well,
whatever I tell you, I do.
but if she's staying in your house and she's possessing felony drugs, she
Not
could,
going to happen. I can guarantee you she will not possess felony drug in my house. I can guarantee you that.
and is her co-defendant staying with you out there as well?
No, ma'am.
Oh, here. Bible.
What?
Oh.
What'd you say?
My dog is barking at somebody outside, but
So you have a dog with you there in Colorado also?
yeah, he's my little Chiweenie.
Okay.
She's all giddy because she thinks she's getting out of
And
jail.
what kind of work do you do, sir?
I retired, ma'am. Previously, I had a business called I sold technology, is where the wide terminology anyhow, to the public sector, state, local, federal agencies, things like that.
Damn, good for you, dude.
And if I tell you to drive her to the local sheriff, would you do it?
Yes, ma'am.
Okay. Well, I thought I had figured out what I was gonna do with her. Give me a few more minutes. Let me
Yes,
take
ma'am.
out this Reynolds so she doesn't have to keep working.
Thank you very much.
You're welcome. All right, let me check back in with Karis Green. Miss Green, are you still there?
Yeah, I'm right here.
Okay, Miss Green, what's going on with you? You've
You
changed
know.
locations.
Huh?
You've changed locations. You're outside now. We're back on the record in 2022. CR 136, State versus Karis Green.
Sitting
Parties appearing
outside.
as before. Where are you now? You look like you've gone outside.
Oh, I'm just on the balcony.
Okay.
Yeah. This nice house.
Okay. All right. I've given you a court date. Do you remember what it was?
Yeah, November 18th.
You must be here November 18th. At what time?
At 1:30.
1:30. Missy, is that what you show?
That's rough.
You wanna
11:18 at
I feel
1:30.
like-
Yeah.
Okay.
You think
an
everything's
attorney?
cool? You're good.
You're
You
gonna-
got
You
got out
We're
of
gonna
your
call Friday and find
trouble.
out who it is.
I am, yes.
Not happening this time, there,
Ma'am.
sister.
And then
You just wait. It's one of the
we've got
Most
a bond.
very
hearing
viral
for
video.
Motion for judgment on bond, Miss Gillette. Is that
Surprise.
right?
Yes, it's
Let's
on
see why.
November 18th.
Is it at 1:30 also?
It's at 1 just before that.
Okay. Let's
It was
put her-
certified mail to her last known address where her mom lives.
at
She
least where she said her mom lives.
she'll forward it to me here in Greenwood County when she
Okay,
was.
let's just put her at 1 o'clock instead of putting her on both 1 and 1:30.
Okay.
And,
Can we just do it 1:30 since we have a docket?
okay, we'll just do it at 1:30.
Oh, you.
And I'm going to leave her bond active, or her warrant active.
You're gonna leave my one. Is there any
See?
way you could like? I
She thought she was scot free.
quash it. Ma'am, I know I'm messed up.
Don't use that language in court, that's contempt.
I'm so sorry. I know I messed up. Big time. And I really apologize for lying to you in your court.
Oh.
That was
Now
really
you do.
not a good idea.
I don't think you've ever told me yet why you actually lied and said you were in Alaska right now.
Yeah, it's pretty stupid.
You want to try again?
Let her know that we're here right now.
I just thought maybe I would like get in trouble.
What's up, Wolf?
Because
What's
I
up, my
hadn't
buddy?
told you guys that I went back to Colorado.
Hey,
And
watch the girl,
Whose
bottom
voice
right.
was that I just heard?
She's in a Zoom call over court, and she was supposed to go to court, but she didn't show up, so she cost her mom $7,000. And so they found her address where she is. And
that
guess who
is
showed up
Marshall.
while she was?
Who's Marshall?
Marshall Goings.
The marshal showed up while she was on
All
court.
right. Are you
on
there
Zoom.
for her on her warrant, Marshall? All right.
I am.
But
And again, why didn't you tell me you had a marshal there to take you into custody?
I was getting to that. I was.
Right. Okay, well, you're going with him now then. We're gonna quit playing games and
I wasn't trying to play games with you, miss. And I really apologize for lying to you in your court. It wasn't right. I'm just
Go with the
trying to do
officer.
the right
you've taken
thing.
enough. I'm sorry, I'm cutting you off there. You've taken enough time of the officer. How long's he been there?
Just took like 5 minutes.
All right, well, you go with him. You go with him. All right,
Bye.
thank you.
What's my bail at?
Well, he can tell you when he gets you down there and looks at your warrant. You better call your mom and tell her you cost her $7,500 on her bond,
Yeah, you're not getting out.
and we'll be in recess.
Got no one
at
else
this
to bail
time.
you
Thank
out.
Officer.
Thank you.
That's why you don't burn bridges.
So sorry, but. All right. Can't believe that.
Stupid, man.
I'm sorry. I'll call. Once
That's
I-
where lying gets you.
Yeah, absolutely. Absolutely. Anybody, don't take. Go with these guys. Don't.
Wait. What did he say? Did he say he's gonna bail her out?
It's not going to be that tough. I'll watch the dog. The dog will be fine. I guarantee you that.
We get a confirmation.
But
Go for it.
it's not going to be that tough. I'll watch the dog. The dog will be fine. Yeah, absolutely. Absolutely. Anybody, don't take. Go with these guys. Don't. Can't believe that.
I want to see what he says. I'm sorry, I can't watch.
Yeah, absolutely. Absolutely. Anybody, don't take. Go with these guys. Don't.
God damn it, I didn't hear it.
I'm sorry. I'll call. Once I. Yeah, absolutely. Absolutely. Anybody, don't take. Go with these guys. Don't. That's all you can do.
Go for it.
It's not going to be that tough. I'll watch the dog. The dog will be fine.
This dumbass is gonna go bail her out. She just cost her mom $7,000.
I guarantee you that.
We get a confirmation.
Yeah, poor you. Fucking get out of here. You fucking lied. Did she think anybody feels sorry for her? The fucking sheriff was laughing. She does that every time she gets on there. She cries and she does this pouty face and It's like oh,
We're
here
on
she
the
is again.
record in 2022 CR 136, State of Kansas versus Karis Juna Green. Is Miss Green here?
Believe
Miss
so, yes.
Green. That's her
Yeah.
name, Miss Green.
All right. Do we have lab reports on Miss Green's case?
No, Your Honor, we don't. Or I'm not aware of any. Still up might have it, but
Miss Green. Whoa, shit.
Not have lab reports. Judge, I did get a bond violation information sheet from Court Services Jessica Morgan. Miss Green is not reporting on her bond supervision like she is supposed to. Her bond included a requirement to report to Court Services weekly, and she's supposed to be calling in Tuesdays at 8:30 a.m. Has not done so.
What a shocker.
All right, first
And
order
you're-
of business, we have no lab reports. This happened July 29th, but we still don't have lab reports in November. All right. No labs. This too will be continued to January 20th. Much to my displeasure, January 20th at 1:30. Second order of business. Last time I talked to Miss,
Wolf.
hold on a minute.
What's up, dude?
Thanks.
Okay, I said that wrong. Now, this happened August 23rd, and we still don't have lab reports. But nevertheless, January 20th at 1:30. Miss Green, where are you? And this time, tell me the truth.
I'm in Colorado Springs, Colorado.
Did you
I
show
did
up for
answer.
that extradition hearing
I've been
the following
talking to you
day
for
after
like
our
the last 5 minutes.
conversation?
Fuck.
Well, let's start over. Do you remember our last conversation?
I've been talking to
Yeah,
you for
when I
like
got out of jail.
Do you remember our conversation on Zoom
5 hours
in
later.
court?
Yeah,
been
that
talking-
you weren't going to
I've been talking to you since
you were going to keep my warrant
that
Right.
girl
active.
got arrested.
And I believe the marshals took you into custody, right?
Haven't even
Yeah,
been on
and I
for
went
5
to
hours.
I went to jail.
And you
And I
had
got out.
and they set you an extradition hearing. Do you remember that?
Yeah, but I never got any
Yeah.
of the like information for that.
Well, it's impossible for
Because
me
I
not to.
remember it was supposed to be on Thursday, but I was still in jail
Right. So
during that time.
my understanding is you missed a court date out there. You failed to appear. What do you have to say about that?
Okay, so after I got out of jail, my laptop and my
Shit.
antibiotics and my phone got stolen and my purse. And so then I got really sick. I had to it was pretty bad. And
timing,
I had
I
to go to the
guess.
hospital and get like antibiotics. Just like some,
Okay.
yeah.
So are you
And-
still staying with that kind gentleman that you were with when you saw me last?
No, I'm not. I haven't had any contact with him.
All right. Where are you now?
Can't imagine why.
I'm over off of, I'm in downtown Colorado Springs.
Well, I want an exact address. Where are you?
I
Ooh.
am at, I need to find the address. Sorry.
I wonder if she's gonna all of a sudden just go away. Yep, there she goes. Oh, okay, never mind. She's gonna disappear.
Let me know when you have it.
Yep, there she goes. She disappeared. No, I guess not.
So, Miss
guess-
Green, you don't know off the top of your head what your address is?
It's 3,000 and 3,030.
Guess I'm not giving her enough credit.
West Pikes Peak Avenue.
Dude, she's been moving.
West
She's
Pikes Peak Avenue,
moving
Yeah.
all around, all over the place.
Colorado Springs, Colorado. What's your zip code?
She's been couch surfing.
80904.
She has a
Okay.
tattoo above her eyebrow. What is she
30904.
80904.
doing? What is with
Say that
people
again,
nowadays?
please. I'm not getting it right.
8080904. And I
Should be-
lost Jessica Morgan's number, and I've been trying to get it, but I didn't
She
know where her number was at.
She'd be
And
a
I've been
hell
trying
of
to
a
lock
lot-
her
That
number.
zip code's not working out for me.
80904.
She'd be a hell of a
And
lot
then
cuter without
dash
that
something
fucking
else?
tattoo.
I don't know the dash.
All right, okay. All right, and who are you living with there?
I'm living with my friend Roy.
Your friend Roy? What's Roy's last name?
She's lying
Smith.
again.
Roy Smith. Okay, is he in any trouble with the law?
No.
Okay. All right, so you failed to attend
Fuck
the court
you.
hearing you had in Colorado, is that right?
I have no chance with her.
Yes.
No?
Yes. I need to I
Oh,
need to
darn.
call Colorado, my attorney in Colorado,
I was
And-
hoping so.
see if I can get something figured out with that because I was
I
really
always wanted a
sick
girl
at
with a
the time
face
of that.
tattoo.
Okay,
And
you
and then
do-
I just got over like a really bad like pneumonia type cold.
Pneumonia
like
type cold.
Okay,
Yeah.
so you have an
Gotcha.
attorney in Colorado. Who's your attorney?
I don't know it off the top of my head. I just remember that they kept the attorney that I had when I went to jail
She writes me every week.
just in case something were to happen. So I
She's
I
gonna-
will call them after this and get that information.
Okay.
And she has another
Miss,
face
then-
tattoo.
Miss Gillette, are you wanting to take up some kind of motion hearing today?
Judge,
She's
we
got
would
my
just
name.
say that we would like the warrant to continue and the warrant to continue with no bond.
Damn.
She needs to,
Well, I'm not gonna take the hearing up, the motion up and make all these other people wait. So let me, once again, Ms. Green, put you on hold and let me come back. Let's take up some of these other people that don't have the kind of issues you do. So I'm going to be in recess on Green. Don't go away, Miss Green.
Okay.
Well, last time that
Okay,
happened, she
so
went to
Miss
jail.
Green is in Colorado Springs at 30, well, we've already got that. Now, Miss Green, you seem to be having a situation where you want to appear on your time.
Dude, that fucking tattoo completely ruins her face. I don't know what she was thinking.
Instead of the court's time. I told
Seen that.
you the last time you phoned in for a Zoom hearing to make sure that you surrendered on all your warrants. Have you done that?
No.
I need to work on
'Cause,
that.
like-
Like I said, I didn't have a phone, and it was
like
like other people around me didn't have a phone. Like they wouldn't have service, and it was like this whole big mess. And it was,
that would have worked in like 2006. Even then,
But-
people would still say, "You got a house phone. What are you talking about?"
I did get a job.
Well, before we go to your job, let's talk about these warrants.
Yeah.
Since I'm in Kansas and you said you were in Alaska, but in reality you were in Colorado,
Yeah.
and you're not turning yourself in on your warrants, and you're managing to get Zoom codes and call in on Zoom every so often, what am I going to do with you?
Let her go free, of course.
I know that I made a big mistake for missing court that day. trust me, I really wish I could go back time and just, I don't know.
Mr. Ambrose, I don't know if you're familiar with this Miss Green's history, but I think I've just summed it up. She's kind of waving it in the court's face that I can't.
You know what? Funny you say that because I'm thinking about getting rid of my cell phone to get get just a house phone. But at the same time, if your car breaks down, what are you gonna do? They're just they're so hard not to have. You know what I mean?
I can't get her here in person when I tell her to, and I
No.
can't get her to turn herself in on warrants when I tell her to.
No.
I'm not trying to wave it in your face. I was just trying to show up for court.
Show up for court on her terms. But the last hearing, she told me she was in Alaska at the beginning of the hearing. Come to find out, she was actually in Colorado.
She's never gonna
I
let
believe
that
she
go.
was actually arrested while she was in the Zoom hearing.
Yeah.
How many warrants, Miss Green,
Yeah.
do you have out right now, if you know?
I just have yours and then Colorado's, but Colorado would go away if we were able to like settle this Kansas's warrant.
So they have you
How
on a
does that
failure
work?
to appear warrant on the extradition.
Yes, that I
So,
The
Mr.
sheriff.
Ambrose,
got
you have any?
mixed up with the
Sheriff does not like her one bit.
Let's see if Mr. Ambrose has anything to say on this, sir.
Yes, Your Honor. So, like you said, I'm relatively new to this, and I knew that there was some extradition stuff going on. Wasn't sure the full extent of that. What my request would be, Your Honor, is that while we've had it sounds like there's been some issues prior to me getting involved. She has appeared here today. She has been in contact with me. I had a phone appointment with her earlier this week.
He's new, so he's gonna try and give her a chance, and he's about to find out that that's not what you do with this girl, because she'll screw you over in a heartbeat.
Our request would be that the warrant be lifted with.
You see it? she's got a big smile on her face, like this poor guy doesn't know, and the undersheriff is shaking his head.
You know, the understanding that she has be showing up for future hearings. You know, the understanding that she has be showing up for future hearings. She did inform me that she was in Colorado when I spoke with her the other day as well. That's consistent. Would ask that warrant be lifted and that we continue moving forward. We do have it set for a status on 1/20 of 22 at 1:30. And I understand that it sounds like she got herself quite sideways with the court before I got involved. And I will do what I can to make sure that that is not an issue again.
I also need Jessica's number.
You need whose number?
Jessica Morgan's number.
Well, and she's your bond supervisor. And you have Miss Morgan. I understand she has not been seeing you.
Oh, there she is.
I tried to
staying in
flip.
contact with you.
That is correct, Your Honor.
Has she made any contact with you at all?
She has contacted me right after, I have the notes here. She called me 2 days after court, and we discussed that she would call me Tuesdays, 8:30, every week. She had her first appointment on October 4th, and she did not call. So I contacted her number, and it was disconnected on the 13th. Also contacted another number in Odyssey, and it was her mother's number, and I was provided her new contact number, and she did not answer. She did contact me on October 15th, but that was a Saturday at 10:45 p.m. After that,
does-
I have not heard from her.
She does what she
Are you
wants.
available to take her call on the Saturday after 5?
Your
All right,
Honor,
let
it
me
was
try
at
it again.
10:45 p.m.
Oh, 10:45. So the answer is no. You weren't there. You didn't have a conversation.
Oh,
Okay.
oh,
All right, Ms.
never
Gillette,
mind,
what
never
has
mind.
the state to say on this issue?
Whoa.
Your Honor, we
What
have
the fuck?
continual problems with Miss Green not coming to court. I'd like to get her case wrapped up and done. I am still waiting on the lab results, but she misses court, then she calls in and wants it rescheduled on her time. She's got outstanding warrant for her extradition in Colorado because she didn't show back up for it. She's been dishonest with the court, not reporting to her CSO. We got the second chance to report
very
to
smart.
CSO. I mean, the court has bent over backwards for Miss Green is not bending over backwards for the court. At this point, all she's done is be untruthful and not show up.
Yep.
That's all I got to say.
Okay. Under Sheriff Cox, have you anything to add?
There goes my
I
bike.
completely agree with the state's opinion, and I feel that she needs to do the right thing and go turn herself in.
Yep.
Well, we know I've told her that. I don't know how many times. Okay, I'm going to tell you, Ms. Green, the warrant's going to remain active under Sheriff Cox. I want to make sure there's a no bond hold on that so they don't, if I can help it, they won't release her on a bond where she can fail to come to court.
All you have to do is call people. That's
Like
it.
last time.
We'll need to update that, Miss Gillette.
Whatever we need to do to get a no bond hold on that, if they will honor that. And
They will, Your Honor.
okay, because if we get our hands on her again, I don't want her running off again because she hasn't kept her word to them and their bond any more than she has to me and our bond.
Yes, Your Honor.
Are you
Shake your
turn
head. What do you
yourself
mean,
in, Miss
no?
Green?
You're not getting away with it anymore.
Miss Green, was that an answer?
What?
Are you gonna turn yourself in?
I would turn yourself in if
Yeah,
I were you.
trying to work on it.
Oh boy, here come
When are
the
you gonna
tears.
turn yourself in?
As soon as I can get the money to get down there.
Uh-huh.
I just started a job.
Turn yourself into Colorado.
The jail there is really bad.
What was that?
Listen, Miss Green,
The jail
you're gonna
in
get a free.
Colorado is really bad.
You're gonna get a free ride from us here. You don't need money to get here, and you have to take care of your Colorado warrant also.
I know, but my Colorado warrant would go away. The charge would be dropped if I were to
Turn yourself in.
get the warrant.
Or
Quashed
if
in
you go to jail.
Kansas.
Well, your Kansas warrant isn't going to be quashed.
I know
don't
that.
believe you're gonna turn yourself in, and I think you're going to get, as Under Sheriff Cox said, a trip to Kansas courtesy of the taxpayers. Because I can't trust you to turn yourself in. And so,
And
if she showed, and Mr. Gross,
yes, a couple quick things before we wrap this up. I'm sorry for cutting in, Judge.
That was
so
a boss thing to say.
With the status of this now, and kind of the tenor of the court to where we're at right now, do you still want to keep that preliminary hearing status set for January 20th, or do you not want to set it for future proceedings at this point, or how do you want to handle that, since she does have that outstanding warrant that has to be resolved before we can do anything else?
well, I'm going to tentatively leave it on there in case we get her, we can use it.
Okay.
You see
And
me
then-
talk with leaving it on the docket as a, in case.
No, Your Honor, I just wanted to make sure we're on the same page. And then
No.
secondly,
Yeah, but I am going to order that she appear personally for that hearing and not by Zoom.
okay. And secondly, Your Honor, and I don't know what language is normally used in the or in your judicial district, I'm sorry, not the 8th, you're not the 8th,
13.
in your judicial district for these no bond hold warrants, but is the language used normally no bond set until first appearance then?
Yes,
Okay, thank you. Just making sure that that's the language we were using. I appreciate that, Your Honor.
yes. No bond hold till she sees the judge. And maybe that's where it went wrong in Colorado. Maybe under sheriff, is that what happened there? That they set a bond that she could make and then she didn't show up?
Yes, they did an extradition bond through their court system. We have never received a return on the original $7,000 bond even from us.
I have to have certain paperwork from the Colorado courts to do the governor's warrant, and she hasn't even got to that point because she didn't show up for her hearing there.
Okay.
Because we're prepared to do the governor's warrant as soon as we get that information so that we can bring her out here to finish her case.
Well, I know a lot of courts will accept the bond recommendations that go with the warrant. So maybe rather than no bond hold, I just need to set a very high bond to try to assure her appearance. Under Sheriff Cox, have you had any experience there with Colorado to know whether I'm better off with a no bond hold or setting a very high bond?
No bond hold, Your Honor.
Okay.
I don't believe they can set an extradition bond there if she's on a no bond hold.
All right. Well, I want to make sure I get you back here, Miss Green, and I just haven't been able to do it any other way. All right. Anything further, Mr. Ambrose?
She won't turn herself in.
Not for me,
She'll
Judge.
bet your
Thank you.
ass.
Thank you. Ms. Gillette, anything further from the state?
Not on this matter, Your Honor.
All right. Thank you all. We'll be adjourned.
She needs Miss Morgan's phone number, Your Honor.
Oh, can we put them in a...
Is there really going to be any value? I mean, are we going to just be tying up Miss Morgan's time if she's not even going to be really on bond? At this point, she's not really on bond as I see it.
No, she's not.
She can tell Miss Morgan where she is, but it sounds like she changes addresses and phone numbers so fast.
Sure
you can't
does.
keep up with her. So I'm not going to make Miss
I told
Morgan,
you I got my phone stolen. And my
Oh, of
phone stolen.
course.
I was in the hospital. I got sick.
Oh. Gotcha.
Okay, but you're well now. Are you?
I still have a pretty bad bronchitis cough.
Of course. That's something else now.
This person you're staying
You
with,
gotta
is that a
take
good friend that you've known
responsibility
for a
for
long
your
time?
actions there, woman.
Well, I only got to Colorado in March of 25th, minus a month
So
because I
it's
was
just
in
some-
Vegas. So anybody
move
that I
around
know
so
here
much?
is from March. But yeah, I
Why
trust
are
them.
you moving around so much?
Huh?
Why are you moving around so much? You said you were going to go to Alaska and stay with your mother.
Yeah, Andy.
All right, we'll be in recess at this time.
Forget about
Thank you, Your
it.
Honor.
Thank you.
Was that her or her dog
Missy, do we have anything else on the docket?
whining?
I don't believe so.
What's her name? Miss Green. Mrs. Green. All right. Oh, we got another arrest on Zoom. Hell yeah. Oh, is this the same one?
Good afternoon.
Good
Oh,
afternoon.
this is Ms.
Judge.
Green. This is probably her first court appearance, maybe? Because she's in
Mr.
Colorado right
Ambrose,
now. Oh,
Yes,
this
Your
is
Honor.
before she had her
is
tattoo.
this your client at the Greenwood County Jail?
Yes, that's Miss Green.
All right. How do you pronounce your first name?
Harris.
Eris?
Harris.
Yeah.
Okay.
Oh, no, never mind.
We
I
are
see
on the
it.
record in your case in 22 CR 136. The state appears by and through Ms. Gillette. I
Yeah, she
believe
keeps
we're scheduled for an
escaping.
arraignment. There was a violation of pre-trial supervision, failure to appear. This case has gotten kind of old. It is under the amended complaint, 1 count of unlawful possession of a controlled substance, and count 2 is a misdemeanor, and count 3 is another felony
What the?
drug. What's the felony drug in count 3? Fentanyl. All right.
Dang.
Does your client need a formal reading?
Actually, Judge, we're prepared to enter a plea today to count 1, dismiss the balance of the complaint. She doesn't need a reading, though, however.
Show waiver of reading, arraignment, counts 2 and 3 dismissed, and a guilty plea to count 1. I'm sorry, let me.
A no contest plea, Your Honor, to count 1.
Okay. All right. All right, Ms. Green, when you plead no contest, essentially what you're telling the court is, I'm not going to tell you, Judge, what I did wrong to support the charge, but I'm also not going to go to trial and contest the evidence. So that means that the court listens to the proffer of the state. Had we gone to trial, what they believe they could have proven. And if I find that one reasonable fact finder could have found you guilty beyond a reasonable doubt, I'm going to find you guilty based on your no contest plea. In other words, I'm not independently evaluating your case for its strength or a determination that 12 jurors would find you guilty beyond a reasonable doubt. I'm simply making sure that there's sufficient evidence to support your plea, finding you guilty based on your desire to plead no contest. Once I adjudicate you guilty on a no contest plea, you're treated the same as anyone who originally pled guilty or was found guilty by a judge or jury. In other words, there's no distinction as it relates to sentencing, post-sentencing matters, or anything of that nature, a probation violation or anything. Once you're found guilty, you're treated as an individual who's found guilty of a felony. Do you have any questions about that?
No, Your Honor.
Oh, okay. Now you're on the
Oh, what
drug
the
grid. This would be a felony conviction. So essentially someone who's subject to a felony sentence is subject to the possibility or potential of serving prison as opposed to county jail time. You're only in the county jail awaiting trial on felonies. You can do up to 60 days in the county jail as a condition of being granted probation, and you can do some sanctions, probation violation sanctions in the county jail. But other than that, the underlying sentence would be served in prison if you were originally placed in prison or placed on probation and failed at your probation. The sentencing range is 10 to 42 months with the Department of Corrections, depending on your criminal history. As long as you don't have 2 or more person felonies as an adult or a juvenile, in state or out of state, or 6+ person misdemeanors such as assault, battery, stalking, violating a protection order, any kind of misdemeanor that has to do with crime against a person, then you would be presumptive probation or in a border box. If you're in a border box, if you evaluate for Senate bill treatment, you have a high risk assessment, you have a substance abuse evaluation that indicates a high need for treatment, then you're guaranteed probation. Even if there's some kind of special rule that might apply to you, such as being on bond or probation or parole at the time of the offense, the court's hands are pretty well forced to give you
Holy
an
shit. Holy
opportunity for
snooze
Senate bill
fest.
treatment and probation. A condition, though, of that probation is you have to complete every component of the Senate bill treatment requirements. Okay?
This one's not as
I can
fun.
also fine you up to $100,000. Normally, unless I think the crime's financially motivated, I don't assess a fine. I certainly don't assess one at that level. However, there are always costs, fees, supervision fees. If you've never been convicted of a felony before, there's a DNA fee. There is a KBI fee for testing of the drugs or narcotics. There is a Senate bill fee of $300 that you have to contribute towards your evaluation and your treatment. At the end of the day, even with court costs, that can easily run $1,200 to $1,500. However, you are allowed to make payments during the course of your probation, which can be up to 18 months. Do you have any questions about your possible sentence in this case?
No, Your Honor.
All right. If at any time you do have questions, let me know. All right. Now I need to make sure that you understand the rights that you are giving up. As I indicated to you, I will accept your plea based on a proffer of evidence, but you have a constitutional right to a trial by jury, to go to trial and have 12 individuals who aren't attorneys or judges or lawyers necessarily, who are independent of the case, listen to the evidence and make a determination as to the strength of the evidence. They are sworn to be fair and impartial and to follow the law. Some of the things that they would be directed under the law to do is give you the presumption of innocence. The burden of proof lies with the state. It never shifts to you. Because of that, you're not required to present any evidence, nor can you be compelled to testify. That is a protection afforded to you under the Fifth Amendment of the United States and the Kansas Constitution. You can call witnesses on your own behalf if you desire, but the fact that you may choose not to call witnesses or testify cannot be a consideration by the jury of any evidence or inference of guilt whatsoever. Additionally, the prosecution can't just proffer evidence. They have to bring in live witnesses, bring in the physical evidence. All of that's subject to examination by you, your attorney, and cross-examination by your attorney of anyone testifying against you. That's what's called your Sixth Amendment right to confrontation.
She just sounds like a fucking robot.
At the end of the day, the only way that you could be convicted with the burden of proof on the state and the standard of proof beyond a reasonable doubt is if all 12 jurors agreed on the same verdict. In other words, the state would have to convince all 12 jurors that you were guilty on each and every element of each and every offense beyond a reasonable doubt. And they must be in agreement in order to return a guilty verdict. If you were found guilty, you would have a right to take what we call a direct appeal to the Court of Appeals in Topeka, Kansas. That panel of appellate judges would review the entire trial transcript, ensure that you received a fair trial, none of your constitutional rights were violated, and that there was sufficient evidence to support the jury verdict. But you don't preserve any legal issues or have another court review your case if you don't go to trial in the first place. So you have to go to trial.
So use this if it don't even work.
So when you waive your right to trial, you're waiving all of the rights that are
blah 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 blah.
There was also
blah, blah,
aluminum foil and syringes loaded and used in the area, as well as melted pen tubes, and several other things, with Ms. Green being identified by her Alaska driver's license. The items that were tested on her side of the car tested positive for both fentanyl and methamphetamine. During booking process, Ms. Green informed the detention officer that she does use fentanyl and that the drugs found in the vehicle were not methamphetamine, but rather fentanyl that she had used. So that's the basis for this stop. Some of the items being ground powder in a vial, the pens, the glass smoking tubes, and the foil that all were used to ingest methamphetamine, crystalline substance.
Okay. All right, Miss Green. I find that you're alert and intelligent. You understand the nature and the consequence of entering this plea, and you understand the rights that you are giving up. I further find that there is a factual basis for the plea, and I do find you guilty of possession of a controlled substance, to wit, methamphetamine, in violation of KSA 65-4107 Ed Sec. Actually, it's 65-4105 Ed Sec.
There we go.
All right. I'm going to order a PSI. I'm going to schedule your case for sentencing. I would like to do that on my next half day, Greenwood Elk Day, which would be Wednesday, June 14th. It does take 6 to 8 weeks to put together a PSI, which we have to have at least 7 days prior to sentencing, so that your attorney can look at your criminal history score, make sure it's accurate, file any appropriate motions. I guess my half day is also, though, my duty day in Butler. So I have first appearances from 1:30 to 2:30 or 3. Could you do this at 3 o'clock, Mr. Ambrose, on Wednesday, June 14th?
Well, I was going to ask between 2 and 4, so you got it right where I wanted it, Your Honor. Thank you.
Perfect.
Boom.
All right, Ms. Green, I'm going to add a condition to your bond that you participate in an LSIR, which is a risk assessment, and that
Let me
you
make sure this works.
participate in a substance abuse valuation. These things are necessary to determine whether or not you qualify for Senate bill treatment. I'm going to tell you what I tell many folks is, as I indicated to you, Senate bill folks, Senate bill qualified people, individuals, are guaranteed an opportunity for treatment. So it behooves you during your evaluation.
My God, woman, you are boring. Sorry.
It might be Colorado Springs.
However, she's been in the lower 48 for.
Holy shit, was that girl boring?
We're on the record in 20.
It's like I just fell asleep. Those are the type of judges that never get through anyone. It's boring as hell. Next, they're talking, and then 2 hours later, oh, they're still talking. Best hits, Judge Bryant. Know thine judge. All videos, sovereign citizens. Karens in court. Oh. Oh.
Did something happen to you as a result of that?
No, that's what
Okay.
that's the first thing he said to me. How is that not a problem?
We're here in case 19-6811 DM, Sylvie versus Sylvie. Both parties are present, as well as Miss Van Tol, who represents Mr. Sylvie. This is a motion by Ms. Sylvie, basically to review a provision in the judgment that found her guilty of contempt of court, and the provision at the events, the kids' events, if you will, but no contact, but it could be reviewed anytime after October 24. Ms. Van Tol, this was order following contempt proceedings that was entered June 24 of 2024. The provision that she is asking says plaintiff shall not attend any events or activities for the minor children. Plaintiff may request a review of this provision on or around October 24, 2024. If plaintiff prevails in having this complete restriction removed, the current parenting time order of March 16, 2022 shall be resumed unless this court orders an amendment to the same. She is seeking an amendment as well as a couple of other miscellaneous things on it. Ms. Van Tol, I'm just I didn't get a response from you. I'm not saying anything about it. I just want to make sure that I didn't miss it. Did I?
Yeah, I sent it last week, Friday.
Let me ask you, do you object to her request to dismiss that provision?
I do, yes.
All right, we'll get into it. This is the last motion of the day, so I've got time. Ma'am, I've read your request and your statements in here about all kinds of things that he does that's wrong. What do you have to say?
Well, about the provision, I have complied with the directives to not go to anything. The first thing I'm asking for is to have that removed so that I can resume going to things on my parenting time.
I'm unsure of what all the rest of this then is about.
Well, that was just the first. So then we are having behavior problems with the kids. Mr. Sylvie has been talking about mental health disorders, telling Jude that he has these mental problems and that he needs help, but it's not backed by anything from a doctor.
Okay, I understand that's another request, but what does all of this have to do with it about like picking up from school? And I mean, you're throwing in all kinds of stuff that is statements like the October 9th parenting time. Did you get the kids on October 9th at 11:30 or did you get them at 3 o'clock?
I got them at dismissal.
Okay, so at 11:30 or whatever that was.
Yes, at dismissal.
Well, what is the purpose of all of this in here about, you know, you went through these things back and forth and you got it, but somehow it falls on him as being negative for something.
Well, the purpose is to show that the kids are stressed out. Their behavior problems are increasing.
It shows to me that you're stressing them out.
How, can you explain that?
I don't even, I mean, we go through this whole thing here and it's between you and him and you contact Miss Van Tol and everything and it gets worked out. Why are the kids even involved with it? Why are you saying at some point and adding that he would deal with her later, which left Noah frightened? Why are you even talking to Noah about it?
I'm not. I can't even contact the kids.
Well, then how do you, then why do you put in there, deal with mom later if you don't even know that it came from Noah, according to you?
Right, when I picked him up.
Okay, why does he even have anything to do with it? You picked him up at the time you wanted to.
Yes, sir. That's the first thing he said when he got in the car. I am trying to show.
I don't believe that.
Well, at some point.
Ma'am, you do not have the world's best credibility in the court. You've lied to the court starting back in the trial, starting back even before that, when you wouldn't agree with the judgment that you agreed to and then sent out stuff that was damaged. And I mean, it's all come out. You have abused the court numerous times with not being truthful.
Okay, I understand. But at some point, someone will have to talk to the children, right?
About what?
They are stressed out. There is no reason that
you are stressing them out with all these things.
It's not, so they're not supposed to talk to me?
I didn't say they're not supposed to talk to you. I believe you are seeking from them such things as, you know, you're stressed out because of what? Because dad said he's going to do something to me afterwards. Dad, if he even said that, he'd deal with her later. Fine, kids, you're going to go at 11:30. I'll deal with your mom later. Who cares?
Okay, I just wanted to understand your point that you are okay with that sort of behavior to the kid.
What sort of
They're
behavior to the kids?
that Mr. Sylvie, that Matt would say that to the kids about
Tim,
their mom.
So
You
what?
really don't get it. The other thing in here is you start talking about Mr. Sylvie is trying to change, how do you say it? Demands the Comstock Park overhaul their dismissal procedure to include ID checks, post-school hours, and an
What?
expectation driven by his personal vendetta against Cena and his desire to exert control over her. I read through the things that he said, and all he's saying is, why is the school sending the kids to somebody who they barely know at most and isn't on the pickup list? And somehow you want your kids to get into a car that they don't know who they're with? Is that what I hear?
That's what you read.
That's what I read in here that he wrote to you, but somehow you try to turn that around and make it something that's awful that he's done. I don't even understand where you're coming from.
Sir, in the messages,
Yeah.
the children know who this person is. But why does
Is that person? Who is the person?
she's a family friend of ours from the YMCA.
The kids spend a lot of time with her?
In the summer,
I mean,
graduation open house.
all I know is that they don't even know her last name. Absolutely inappropriate. You don't want your kids getting in a car with strangers, right? Is that true?
Not a stranger.
Answer my question. You don't want them getting in a car with strangers, right?
Oh.
And aren't they supposed to get into cars with approved individuals?
They are approved by me. It's my parenting time. They're not getting picked up during school hours, sir. It's after dismissal.
How is it okay telling Noah to get in a car with someone he doesn't know very well? This is a very bad idea, and I think I should tell the school to make sure Noah gets, doesn't get picked into a car with anyone that he is not on the approval
It's a double
list. Man,
rainbow.
It seems like a reasonable request.
Your Honor, it's not, because it's dismissal. It's not during school hours.
So you send anybody at dismissal, whether they know him or not, and that's a good thing. You want him to get in, so
Yeah.
he
He
should
thinks she's
send
crazy.
somebody that says, hey, I know you don't know my kids, but go pick them up from school.
That does not make any sense, Your Honor. The
Yeah, it
children.
does. You don't make any sense. I'm
Okay.
just telling you.
I
Why is
understand.
it that everything that is done comes back on him as you're the one who's violated court orders? You're the one who's been held in contempt.
Okay, so just so I understand, Matt can put whatever he wants into an Our Family Wizard message, and that is just what it is.
You submitted it to me. They didn't.
I know, Your Honor. I'm turning things in to show, that doesn't make sense. Everything is a problem for him. He is the one that
Everything
brings.
is a problem for you.
Yeah, no shit.
I am not the one that brings
She's
the
a
kids
nightmare.
into things.
Into what?
Noah being frightened, or
He would have Noah would have no reason or any thought of being frightened just because if it works out and he says, go ahead, kids, you're gonna go to your mom's at 11:30. I'll deal with your mom later. He'd have no reason to be frightened about that
I
unless
know.
you make
Yeah,
it a big
true.
deal.
then that sounds like a conversation that someone should have with him or with the kid.
So basically,
What?
she's crazy.
You're saying that he has no reason to be frightened. That was a
Not
feeling
unless you put him up to it.
he ran to my car, and that's what he said. He was worried. Okay, fine.
Did something happen to you as a result of that?
No, that's what
Okay.
that's the first thing he said to me. How is that not a problem?
I'll listen to what you say, but I don't find it to be credible. I don't think your
I
kid
understand.
ran at 11:30 and said, Mommy, I'm worried because Daddy's gonna do something to you because I'm here.
That's not what he said.
All right, Mommy, I'll read what he said. According to you, what he said, it's in your motion. You want me to read it to you, or do you know what he said?
Oh, but if you would like
Yeah,
to, you can.
go ahead, read it,
Or I can
please.
turn to it. And he doesn't call me mommy.
All right.
Whatever, Mom.
Adding that he would deal with her. It says on the morning of Wednesday the 9th, Matthew instructed Noah to go home with Cena, ominously adding that he would deal with her later, which left Noah frightened.
What are you
He
writing
didn't
a
say he
fucking book,
ran to the
lady?
car and, oh, mommy, he's going to deal with you later. Mom, Cena, I don't care what he calls you. I don't find that after the kid's been in school all day and is now released to you that he's terrified or frightened that something bad is going to happen to you, because stuff hasn't happened to you. I mean, he has no reason to believe that dad's going to show up and beat you up again, Mom. No, he hasn't done it before, so he has no reason to do that. You're just making mountains out of molehills.
All right, understood. This is just creating more problems when they become adults. That's
Yes, it is.
Yes, and
you
you're the one
started it.
doing it.
I don't.
And you have been held in contempt of court because you can't act the way the court directs you to.
Your
You
Honor,
give the
how?
kids that message. You give the kids that message.
I don't get to talk to them.
You give the kids the message. You can't abide by court orders. Okay? You don't think that you do have to.
How?
Because you were held in contempt for violating it. And you said you
Jesus
didn't, but
Christ,
the judge
lady.
clearly held you in contempt, charged you some $4,000, which was to be paid last month. I hope it was, because otherwise you'll be back in court again.
It was paid, Your Honor. Thank you.
Okay? I know you don't blame yourself for anything, ma'am. Never have. I know that you put on stuff about this wonderful guy you were married to, and oh, all these poor things that happened. And it was clearly lies. Clearly.
Understood.
And since then, you come back and do some of this stuff that I don't know what. It's always Mr. Sylvie's fault. He's doing the best he can to raise the kids, following court orders the best he can, and no matter what happens, even when he gives you what you want, you find it to be, oh, the kids are suffering from it. All you had to do, if he has said something, Dad's going to deal with you later, you say, oh, that's nothing. Don't worry about it. That's between your dad and I. I'm not worried about it.
That's what I did, but the court needs to know that these things are happening. And I tried to resolve it with Miss Van Tall, and Mr. Sylvie couldn't let it go. So like the day before I picked them up, I get to talk to Jude on the phone. He doesn't want me to pick him up from school because he is afraid that he's going to get in trouble for going home with me.
Did Mr. Sylvie ultimately say, okay, you can pick him up from school?
To Noah, yes. But I'm saying Jude was so stressed out that he didn't want me to pick him up. And I said, that's fine. That's fine.
Just
And
on
then-
this issue, do you have anything you wish to add, Miss Van Tol? Just on this issue?
Yes, Your Honor, thank you. I just want to impress upon the court that this is not accurate. Again, Miss Sylvie comes in here all the time making false statements. She
making
attached
things up.
documents that don't support her claims. The
She
issue
does-
in this
yeah.
case was my
I know
client
who
was
she is.
attempting
I've
to
seen
work
her
out the
before.
issue with Miss Sylvie in advance. Miss Sylvie kept telling the kids, I'm picking you up, I'm picking you up, I'm picking you up. So Mr.
She
Sylvie did
literally-
not
she'll make
contradict
shit up.
that statement to the children because he did not want them to be in the middle.
Ooh.
So when asked, my client indicated, do not get on the bus. You can go with your mom or whomever
Nice.
she sends. That was the statement that was made. That was the appropriate statement. I am asking that the court set a time because this is continuously an issue. Miss Sylvie is not available until 3:30. My client's happy to say 2:30, which is dismissal from school on a normal day, if that's what it needs to happen to avoid these continued conversations. But the wording in the order currently is problematic since it says after school or as early as 3. And again, just to avoid any further discussion on the matter, my client's fine with the 2:30 time. He just doesn't want to have any more communication regarding this issue, and he does not want Miss Sylvie to continue to put them in the middle.
The kids are dismissed from school at 2:30,
Yeah, about that time, Your Honor, yes.
and she gets them from dismissal.
Right. The issue is that she's trying to get them on half days. They're spending time with these people they don't know because she doesn't have half days on the same day. And I
Wow.
understand she says, yeah, they're people that they've hung out with occasionally. They're not really people that they know well. So again,
That's
he just
nice.
wants a time, and that's it.
Well,
And if the
but
court
it's
says
only on Wednesdays, right?
it's Wednesdays and her Fridays, I believe. Again, to be clear, if the court's saying dismissal, the court's saying dismissal, I will put that in the order. But again, I find Miss Sylvie is not an appropriate parent. I'm very concerned about what she's doing with these kids. I attached, because the court doesn't have my response, and I apologize, Miss Dewey said she got it, but there's text messages that Miss Sylvie is seriously snapshotting OFW messages and sending them to Jude. She does this all the time. She undermines him constantly. It is a problem. It's a problem.
Have you filed a motion to?
I'm going to. Yes, I have to. This cannot continue. And this just happened in October. My client cannot keep funding all of these issues because he is waiting to get reimbursed until Messina pays me, which is always, 3 months later. It's a lot of money that we're expending on continuous litigation with Miss Sylvie because she can't follow a court order.
But you did get paid for the contempt.
God
I did in September, yes, and then my client got reimbursed, yes. But it's a lot of upfront funds.
I understand, and I can't. I'll deal with it when it's in front of me. You filed an answer, okay? You didn't file a motion, so I can't really grant some of the stuff you're asking for because it's an answer versus a motion, okay? But Miss Sylvia, when are you going to pick up the kids from school at 2:30 or what?
Dismissal. So if dismissal is 2:30 for Noah and 2:40 for Jude.
Literally, no, really.
They are going to be picked up at 2:30 and 2:40.
All right. And are you going to pick them up?
Unless I have a conference or an IEP.
Find what?
Yes, sir. Yes, Your Honor. I will pick them up.
Find weapon and armor.
You will pick them up. And if you do not pick them up, you will notify in advance Mr. Sylvie of who it will be, their full name, all right?
Yes, sir.
So that they can even check to make sure this person has a driver's license, because before he didn't, and you were having kids driven around by somebody who didn't even have a license. You make sure that they're appropriate. Basically, 99% of the time, you will pick them up at dismissal. Do you have any problem with that, Miss Van Poel?
No.
I mean, if I adjourn now, Miss Sylvia, I haven't ruled on whether or not you still get to see the kids, because it's October 24 is when I would review that. Miss Van Poel, can you tell me your response? I'm sorry, I do have it and can have it printed out, but you might as well tell me here, right?
Right. So the issue was she filed a motion because her sister was having a baby, right? So she wanted to go out and see the baby at the time it was born. So she filed this motion in the summer. It ended up being in conflict with the kid's school, and it ended up being a conflict with Jude's driver's training that was prearranged well before we knew this request was going to be made by Ms. Sylvie. So the issue is she's made false claims to this court like they never see their aunt. Their aunt's coming into town. She has a week over Christmas break. She can do what she wants to do during her time. She doesn't need an extended weekend to see her sister. And again, I am deeply concerned with what she's doing in trying to alienate, especially the oldest child, regarding Mr. Sylvie. And again, I apologize you don't have the text messages, but it's super clear. She wants to be a friend to a teenager and make my client look like the enemy because it suits her narrative. It suits her goal of making Mr. Sylvie a bad guy to anybody she can, and it's not reality. So I do have an objection. My client does object to her having the extra time. She can she can spend the time over Christmas break. That is absolutely her choice.
Yeah, when's your sister coming in town?
She's coming in for Thanksgiving, but I don't have the boys that weekend. So I asked to switch Thanksgivings this year for next year. Mr. Sylvie said no. But the whole point is for the boys and I to spend time together with my sister and the baby. It'd be nice if they could see her.
They see her every holiday that she's in. I mean, she's around every holiday that the children are spending time with Messina, or Miss Sylvie, excuse me.
I'm sorry, what
Obviously,
holiday?
grandparents want. They saw her in May of 2024, see her multiple times per year, and we're on a week-long vacation in 2022 to visit her, and we'll see her this upcoming holiday, is what my client indicated.
How does Matt know my sister's schedule?
You just told me she's coming into town.
She's for
damn.
Thanksgiving.
Okay,
not,
but he does. But the kids know when they see her.
but they won't get to see her Thanksgiving. I don't have them that weekend. And my Wednesday is cut short.
When
She's
is
not
she coming in?
Tuesday. And then the Wednesday, I only have the boys, or no, I don't have them that Wednesday because it's Matt's Thanksgiving. So they won't have an opportunity for us to go together to see her. I even offered to Matt, can we swap, can I have this Thanksgiving and then you have
He
the
said
next
no,
two?
and he doesn't have to swap and that kind of stuff, and I'm not going to
Right.
make him swap.
She's not coming for Christmas.
My client's fine if she takes them during her Christmas time. That is absolutely not an issue. That's not even a dispute. Go ahead.
But I need the extra time because I can't drive the 14 hours and spend 8 hours there and drive 14 hours back. I need the extra time.
How much time does she have at Christmas?
It's only Friday, 6 p.m. to Monday, 9 a.m. That's all
over
that
the whole Christmas break?
Yeah, I don't have any additional break time, even though I'm off work. And I can't afford to fly Friday night and then fly back Sunday. It's too expensive. Like I have to drive.
I'm not going to order any time like that. The parties can work on trying to, you can work something out. If she's going to be in over Thanksgiving, and maybe he could send the kids over there for Friday or something like that. Be reasonable and see what happens, okay? The last thing we got to deal with then is whether or not I'm going to eliminate that no contact thing that expires on October 20, or that I look at on October 24th.
So the rule says plaintiff shall not attend any events or activities.
Read it.
Yes. Well, I did not attend any events or activities for our minor children.
Okay, but it didn't say that if you don't attend any, that you can then automatically have it back. It just says we'll review it.
Right, that's what I'm asking for.
All right, Ms. Van Tol, your thoughts on that?
Your Honor, I think my client would prefer that she stay out of events and activities only because she continues her alienating behavior. As the court understood at the show cause hearing, she had involved other parents of children that interact with their children, and then their children were getting involved in it. She has been a very disruptive individual, and she causes a lot of conflict pretty much everywhere she goes. So it is more peaceful. It has been peaceful, but there have been very there's been very few opportunities for Miss Sylvie to attend activities over this, 3-month period because we were in the summertime. We are going to ask that it remain in place until Miss Sylvie can stop continuously alienating and sending texts to Jude from OFW, screenshots of OFW messages, because my client disciplined him for being very disrespectful. And the reason he's disrespectful is because Miss Sylvie thinks he should be. He should have a voice. He needs to push back. So then he loses his cell phone, and then he gets really upset. And then Miss Sylvie said, "Well, I'm so sorry, Jude. You must be," I'm going to quote it because this is amazing. She says, "Being punished for undermining Dad's authority over you, like that's a normal thing." That is sarcastic. It is normal. You should teach your children to respect authority so that they don't become juvenile delinquents or criminals. Obviously, she doesn't care because all she wants to do is be a friend. That is not appropriate, and it's alienating, and that is a problem. And again, I don't find her attending events is in the best interest of the children or good for this co-parenting relationship.
She's crazy, dude. She is nuts.
I do agree that text, it's a little bit out of context because the consequence for Jude's behavior does not match. Jude is being treated like a delinquent, but he's not. His escalated behaviors do not, what's the word? The consequence for what is going on does not match the behavior. It's extreme.
What should the consequences
Taking the phone away is too much.
Trying to understand, why is Jude acting out instead of just reacting and taking things away, or taking things away from Jude, but
that's
not
a
telling
normal
him
reaction.
That things have been taken away.
She's crazy.
Like this weekend, Jude was driving without his permit. He didn't know that Matt took it as a consequence. And I didn't know that that was taken away from him as a consequence.
Your Honor, these again are not true statements. Everybody, Jude was very well aware of his consequence, and ultimately,
He was well aware of it.
this issue is mom undermining constantly. Even listening to her right now, she's undermining. This is what she's doing to the kids all the time. It's not good.
I'm sorry, Vince, it's not undermining. It's a conversation about consequences and behaviors. If Jude was a delinquent,
Yeah, she's sick
yes,
in the head.
remove the bathroom from him, like change his bedroom.
You want to
Yes,
wait until he
it's not
becomes a
real.
delinquent? Is that what you're saying? Once he becomes a delinquent, then do some things. That's what you're saying. That's what you just told me.
That is not what I just told you,
Yes,
sir.
you did.
Sorry.
You said once he becomes a
kinda what you
delinquent,
said.
then those are appropriate.
Yes, it's not appropriate. There's steps. It's a mutual respect that they should have with each other in conversations. Jude should feel safe enough to have conversations with Matt instead of just things being taken away. It's okay. That's fine.
You're a shitty parent.
Anyway, if
You let your kids
Matt is
walk all
telling
over
me
you.
one
That's-
thing and telling Jude
It's not the
another,
right way to parent, if you ask me.
it's very confusing. If Jude will say, like, for example, going to see my sister, he tells the children, yes, I will work it out, but then tells me, no.
Well, I
He's
have
trying
kids,
to work
right?
it out.
What do
But
I
it
know?
doesn't. But that doesn't mean it works out on your terms.
No, I'm saying nothing has been tried to have it worked out.
He worked out the thing of the Wednesday with you, but you made it sound like, oh my God, he's, destroying the kids by this. He worked out that you picked them up early when I don't know that you were entitled to, but you got him. All right. He worked that out.
Okay. All
There were
right.
no consequences to you. There was nothing that bad happened.
Not to me, it's about the kids. But
Yeah.
moving on. Can we just?
All right.
I have
Any
to go.
last thing anybody wants to say?
Yeah, I don't think it's about the kids.
The provision
you.
says activities. I did not attend any activities or events.
Boy, she is nuts.
I have very limited contact with people in the boy's life.
I don't think you're
have
appropriate to be around those because of what Miss Van Tol said. You are disruptive when you're around there. You are picking, maybe it's not the right words, but fights so that the kids are being told one thing, not the other. Mr. Sylvie's the primary parent. He's shown himself to the court. At least I don't see that he's lied to the court. And put forth things that are just out of reason.
The fuck, man?
I'm going to maintain that same thing through the rest
Goddamn
of the school
server.
year. That means through till like June. If you want to come back after that, we'll take a look at it.
Can you put a date on that, please?
The school year. I don't know when the school year ends.
Okay.
I will put the date in.
Yes, Miss Van Tol put the date in. I don't know if they end June 6th or May 31st or June 14th. I don't know. It'll maintain through the school year, and if you want to take a look at it, we'll see what happens. I've denied the motion regarding time to Connecticut. I have asked Miss Van Tol to see if there's a way that the kids can see the aunt while she's in town. I know he's got Thanksgiving and that kind of stuff, but I know that he gave in on the Wednesday thing. There's no reason that he can't do something, but I'm not ordering it. Anything else we need to deal with?
I just want to make sure I understand. So the school year, so not removing the provision, has nothing to do with me following what it said to do, but it just has to do with the motion that I filed and the information that I turned in.
I don't know what you're saying. You
So
asked that it be reviewed. I reviewed it, and I don't think it's appropriate to take it off for the reasons that I've said throughout this hearing.
Got it.
Anything else I need to deal with? I'm not
crazy.
Giving you extra time for the Connecticut trip. Anything else, Miss Sylvie, that I need to deal with?
No. No, sir.
Your Honor, I did ask for attorney fees in my response.
Are
Again,
you, well, but see, here's the problem, all right? The judge gave her the opportunity to file this, okay? To ask for it.
filled with
And so-
lies, and that's the
Well-
problem, again.
But he said that I should review it. I can't really charge her because then she has to have it reviewed on the day he said to have it reviewed. You do understand that?
I do, it's just the other things, the lies that are included, the excess of stuff that was irrelevant and untrue that I have to respond to.
I think you're filing a motion or something coming up.
I'm gonna have to file another show cause, yes. I don't think she gets it still, basically.
I can reserve costs for this, but you understand that I'm not, it's unlikely that I'm going to charge her for this motion for the reason that her motion asking for time for her to see the kids to see the aunt is not an unreasonable motion, number one. Number two, the judge said it can be reviewed on October 24, and she filed for that. Quite
Thank you.
frankly,
It's the other things that take time to respond to, and I have to.
I understand. And so you will draft the order that will.
Yeah. Yes, I will draft the order.
You'll draft the order that denies her request and puts it in until the end of the school year with the
Right.
date.
And then the pickup, that'll.
Dismissal
Yep.
is the time for
Mhm.
pickup.
Yep.
Otherwise, are you including in there if it's dismissal or if there's no school, what is the time?
I'm putting in there 2:30 because that was what the end day and the end time was for the other kids.
So if there is no school,
Yes, the 2:30 timeline.
ma'am, it's 2:30 if there is no school.
All right then.
All right, otherwise it's dismissal. And,
All
I think
right,
that's
what
basically
next?
it.
Yep.
Crazy bitch is done. Brings her baggage into small claims. Let's see what we got first. Let's watch a judge get pissed off at the DA.
She needs to get back in here at 1 o'clock.
Yeah,
I want her here because I need a message gotten to that office right away. Court calls case, People versus Don Lee.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee. All right. Hey, where are we on this case?
Thank you, Your Honor. This is a driver's license case and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
Let's have Mr. Lee's one.
Raise your hand, raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee. This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind, but
Yes.
you cited an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will? Because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court
Sorry.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
I do
Anything you
that.
want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on the other thing tomorrow. Is it tomorrow?
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what
Yes,
we did?
exam is on the 8th.
Before me? Okay. All right, I'll take a look at that, because I just, all right.
I think I have a file out there, and if the court have a question I can help with.
Well, I put him into custody, but I know I told him I was gonna take a look at that on the remand into custody on it, because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes, all right, that's right, that refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying, because I don't know, did I change his bond on, I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to get, there was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the 2 cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were supposed. What's the status of that other case?
Your Honor, Ashley Lottie for the people on behalf of talk about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
Oh, here we go.
I don't know the exact
Yeah,
charges
fight
that
this
were to be
freak.
authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
I know.
Yeah.
Listen. Where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded
Might as well
because
get
his
some-
other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace And the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I won't say, I can't say for sure, may have kept him in custody. Which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go, look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was.
The 20.
Gonna fight the spider.
I think it was the 26th. He was before me.
I have some help helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated date of incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26.
Who's that phone?
But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
no, that will not happen. Miss.
Can you tell me what the jurisdiction is? Yes.
It's
not in.
Ypsilanti City. It's Ypsilanti City.
It's a city case?
No, I showed us
It's a
14B.
sheriff's office. It's a sheriff's office arrest that
damn it.
occurred in Ypsilanti City.
I show with the 14B.
Okay, so it's on the line. Said the swear out was on the 30th.
You're gonna follow this guy. Ah, damn.
Yeah.
I have a police officer.
Oh, really?
Yes.
So, whoa. Is that what the log notes indicate?
Yes.
So, there are no charges?
Correct. It says court does not find
Yes, hold. That's what it says?
Yes.
So there is no case?
Can I confirm the police report number for that? Yeah, I have it. Washoe County Sheriff's Department report number 24-67821. I have 68821. I don't know if that's typo.
And?
Yeah, he's not happy.
Yes, and while you're checking with them, have me bring them Mr. Lee's on 2 cases, 100% litigate. Immediately. That's the last one I had. Now. Okay, let's. Mr. Lee, that's what we're gonna do. I'm gonna have them take you back.
Okay.
And we'll, court does. I haven't sent it. Okay, I took the plea, but he didn't touch it. All right. Court calls case People versus Billy Pauley.
Ashley on Christopher.
Court recalls case People versus Don Lee.
Sarah, is the court calling the felony matters or just?
I am calling the felony matters also.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right, please state your name again for the record, sir.
And I'm calling so that we're clear, 24 FB 1322, as well as 224 F 1261.
It was 1322 and 24-1261.
The felony matters, yes, ma'am.
Thank you, Your Honor. Ashley Lonnie for the people in both of those matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on was not, there was no probable cause found. And so that was not done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me in custody. The prosecutor's office, I think, was given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I sentence him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request to be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. And on those cases, both will be set at personal retirement. The conditions will remain. They never left. It's just they took his liberty on something that didn't get authorized. You're going to be free to go, Mr. Lee.
I'm going home today?
You're going to be let out, sir. Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
He's not supposed to be in jail. Basically, that's what it comes down to. He wasn't even supposed to be in jail, and he's been sitting in jail the entire time.
Has the state prosecutor left?
He rightly got pissed off.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes. At 1 o'clock? I want her here because I need a message gotten to that office right away.
Whoops. Yeah, he was not happy. Got a guy sitting in prison for absolutely no reason. And no one did anything about it. Yeah. It's a good thing he said something.
It's just they took his liberty on something that didn't get authorized. You're going to be
crazy.
Free to go.
Yeah, I'd be pissed too.
You're going to be let out, sir. Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All right.
Go, you're free food.
The 14th District Court for County.
He's pissed off with,
Judge Jay said
I'm wondering if the city's going to get
state
sued.
prosecutor left? She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes.
That's crazy, man.
At 1 o'clock? I want her here because I need a message gotten to that office right away.
It's not very often he gets mad.
Court is recalling the cases of the people versus Don Lee, both his felonies and his misdemeanor cases.
Good morning again, Your Honor. Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Lee.
I'm going to waive Mr. Lee's appearance because they took him down to be processed out immediately. But I want to make a record clear and know, and I realize, Ms. Lundy, you were not the one involved, but I am more than livid right now because this case we went back and checked our records. Mr. Lee was taken into custody on the people's representation regarding the previous case. I took him into custody at 11:43 a.m. on June 26th. After having him wait here in court, I took him into custody on that date, and it's important, at 11:43 a.m. on the 26th. There was an attempt to swear out that case that was done before Magistrate Fink less than an hour later at 12:31 p.m., where the magistrate did not find probable cause. This court was not informed. Mr. Lee was in custody. It was another attempt made to swear out that complaint on the 30th. Again, no probable cause.
Oh my God, he was in there for like 2 weeks.
Inexcusable that the prosecutor on their representations had this court act that deprived Mr. Lee of his liberty for 7 days. Inexcusable.
Sorry, 7 days.
So, Ms. Lundy, again, while you are not the person that was involved in this, but has done, I will expect a call from Ms. Burton Harris regarding this matter.
Yes, Your Honor.
Today.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Oof. Man. Boy, I would be fucking heated. The guy was super chill about it, too. I think he knows he's getting paid. That's probably why.
Hi, this is Attorney Mike Goodman coming to you from Chicago, as usual, and today we're going to look at Sovereign Citizen Court Fail number 2. Let's do it.
Boys.
Okay, we are on record now in the matter of the people of the state of Michigan versus Juan Roberto Jaso. It is file number 20-19801-FH. Today is the date set for a pretrial as well as a motion hearing on the motion to withdraw as attorney filed or defendant filed by Mr. Noe.
Well, of course, we're off to a good start.
I'll find something
He's been
else.
charged with something, but here we are on a motion to withdraw as attorney of record. I'm guessing that's a public defender, and he is trying to get out of representing this particular defendant because, of course, he's a sovereign citizen and he won't listen to him.
We are proceeding today as a video conference as opposed to in
ever watch
person
Sovereign
due to
Citizen
the
stuff? That's fun to
COVID-19
watch.
pandemic. And we are
'cause they're
streaming the
crazy.
video conference to YouTube channel in order to meet the court's obligation to provide public access to its proceedings. First, let me ask the attorneys to place their appearances on the record and indicate whether they have any objection to proceeding in the way that I described, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brunner, Assistant Attorney General for the People. I do not have any objection to proceeding as described.
Thank you, and Mr. Noe.
Good morning, Your Honor. Charles Noe appearing on behalf of the defendant Juan Jaso. We have no objection to proceeding as the court has indicated on the record.
All right, so
Ever watch
as an
Sovereign
initial matter, we have
Citizen
a
stuff?
motion to withdraw from representation that has been filed by Mr. Noe. Mr. Noe, is there anything that you'd like to say regarding the motion?
Yes, just briefly, Your Honor. There's been a breakdown of the attorney-client relationship pretty severely between myself and Mr. Jaso. I don't really want to get into specifics because I'm representing him and I don't want to act against his interest. But there has been some pretty serious breakdowns and some disagreements on the course of representation.
Peanut butter jelly sandwich.
I can relate to this a little too much. I've actually withdrawn on cases before, and I know exactly what the attorney's going through here. You want to get out, and why you want to get out usually is the fact that your client is crazy, but you don't want to say that and prejudice their case and them going forward. At the same time, your client and you want to part ways, so you have to say enough to get out. So that's just where we're at.
Hi, this is Ali with the Sovereign Citizen Patrol, and thanks to all your generous support, I'm getting belly scratches. So please remember to hit like and subscribe so it gets some more.
And the direction that the representation will
It's
head.
surprising how
I
much
do
following
not believe
he
that this
has,
sounds like
'cause his
Representative
videos are
Jaso
so
the way he wants to be
cheesy.
represented. And I believe that I
Fucking Mike,
cannot
but
represent
he's a
him
good guy.
properly at this time.
I will say.
And I would ask to be I will withdraw at this time from representation. I'm not sure how Mr. Jaso feels about that, to tell you the truth.
Mr. Jaso, Mr. Noe has requested that he be allowed to withdraw as your attorney in this case. Do you have any response to that?
Absolutely, Your Honor. Number one, I definitely want to state to the courts that I have to challenge personal jurisdiction, number one, Your Honor, and I understand you want to determine whether I'm going to receive a legal representation.
Well, thank you for making my case on my motion to withdraw better than I ever could have. The attorney was tripping all over himself to not say anything bad about the defendant. And of course, the defendant comes out and starts with the jurisdictional thing and all sorts of other craziness, which makes it clear to the judge why exactly the attorney cannot represent.
Or not. However, that was our problem as far as me and Mr. Noe goes. And I had asked him to file a certain few motions to the courts, which he did not. And he claims that he represented me, but I'm claiming he did not represent me.
He refused to file my motion to challenge jurisdiction of the court. He refused to file my motion to say that I'm a UCC filing and not a human being. He refused to file my motion to say that I was engaged in my unfettered right to travel while I committed the offense. And I just can't get along with him.
And again, I'm saying I am not that name. That name is a fictional corporation. That name is a straw man. That name is a legal person. That name is the estate. And I am the man. And you.
I am the man.
Mr. Jaso, your audio has cut out at the very end there. I need you to repeat just the very last thing that you said.
Everything you said.
Don't worry about it, Judge. We all know it made no sense whatsoever.
I'm still not getting any audio for you, Mr. Jaso. Okay, I can hear you now.
It seemed to be there was some sort of a breakdown. It stated it came up on my computer that there was a breakdown in.
All right, so Mr. Jaso, are you objecting to Mr. Noe's withdrawal as your attorney?
Did we lose him?
I can hear you now, but it did fall out.
Let's go.
All right, are you objecting, Mr. Jaso, to Mr. Noe withdrawing as your attorney?
Didn't I? I wonder if I can beat her.
It's hard to tell here if this is a problem with the technology or if it's just his complete lack of understanding.
What?
No, I don't believe he can represent me and
shit.
In a fully. And that was the breakdown in our relationship. He wasn't representing me according to what I believe.
Well, here, I'll give him a break. That's actually a rational statement. He was not representing you according to the things that you believe. That is correct. The things that you believe are wrong. The problem that he's got that you don't have is that he's an officer of the court. And if he files something that's not well-based in law and fact or a good faith extension thereof, he can get sanctioned or have problems. He's not going to file the motions you want to file because they're not. They're not a good faith argument based on the facts and law. And he has consequences for it and you don't. So if you want to persist with those sorts of things, I guess you will have to represent yourself.
Am I right? And so forth.
All right, so at this time then I will grant Mr. Noe's motion to withdraw from representation. Mr. Noe, would you prepare an order granting your motion?
Of course, I'll have that prepared within a day or two and have that submitted to the court.
All right. Mr. Jaso, would you like some additional time to seek a new attorney?
At this point, again, Your Honor, I'm going to challenge jurisdiction. I don't believe we have jurisdiction. The personal jurisdiction has I don't think it has been established. So, I mean, first and foremost, I do not wish to waive any of my personal jurisdiction rights. And again, I want to state for the courts, that name is not me. That is a straw man. That is a legal person. That's the estate. That's a fictitious corporation. I am the man, and you may refer to me as John, please.
John.
Yes, please.
All right, so do you want some additional time to seek a new attorney?
I just don't even know what to do with that level of stupid. I'm going to ask the question again.
I wish to raise jurisdiction now, Your Honor.
Sounds drunk.
Asserting my constitutional rights and jurisdiction has not been proven or established. That's what I wish to raise at this point in time. And from my understanding, jurisdiction can be challenged at any given time in any proceedings. And I wish to proceed and raise jurisdiction at this moment.
Yeah, we've heard you don't think there's jurisdiction. Of course, you know there's jurisdiction, but we've heard that's all you've
Or else
said
you wouldn't be there.
multiple times. This is pretty good here. Coming up, the judge handles it really well, I think.
If you don't believe they have jurisdiction, why are you sitting there?
Watch the bottom right. The prosecutor, Sarah Brenner, I guess they're calling her Assistant Attorney General. Watch her facial expression as he unloads his next pile of stupid.
And also, again, for the record and on the record, and I'd like the record to reflect, I am not that name. I am the man, living, breathing man. That name is a fictitious corporation. It is the legal name. It is the estate. It is the straw man. That is not me. And I wish to address jurisdiction at this point in time, Your Honor.
All right, you've raised this issue of jurisdiction, Mr. J. So you've not made any comprehensible argument as to why the court would not have jurisdiction over you. The name of a person is not legally a straw man, a corporation, or an estate. A name refers to a human being. The court has jurisdiction over human beings, and at this point, I'm going to deny any request to the extent that you've made it, that the court dismiss the case because it does not have jurisdiction over you. I do find that the court does have jurisdiction over you, but I will protect your right to raise that issue in the future if you would like to have another attorney represent you. So again, would you like some additional time to seek new representation in this case?
Let me add this to the courts as well, Your Honor. I am not here voluntarily. I'm not here. I'm here under duress, under threat, under coercion, because I am here. I am not here on my own free will. Other than duress, threats, and coercion. And
oh, this just makes me insane. I hear it so often, this argument that they're under duress or whatever. They're not there of their own free will. No criminal defendant in the history of criminal law has ever been in court of their own free will. They're all there because they want to avoid penalties under the criminal code to the extent possible. That's how the law is designed.
You are asking me to assert whether I will be receiving an attorney at law being here to represent me, and that is impossible, unlawful, and illegal, and it is against your constitutional oath to force one upon me. And at this point in time, I'd like to establish jurisdiction because I have not received any establishment of jurisdiction.
Mr. J. So I've just done that for the moment. My finding as the judge in this court is that this court does have jurisdiction over you as a person. And if you would.
Here's a good sovereign citizen one.
All
This
right.
judge don't
Good
play
morning. We're
around,
going to
man.
go through the docket as quickly as we can so that we
He's
can
a
start
nice
on the
guy,
jail
but
docket.
man, he does not
2021
fuck
CL
around.
19158, State versus Matthew Aldridge.
He don't fuck around.
Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Fact.
Attorney
what?
of fact. And what does that mean?
His authorization to do legal.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
Man, I'm the attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't you the court just let me file this document?
Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here.
All right, I'm
All
looking
right.
for aluminum.
This is in the state of Tennessee, in Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
Oh, shit.
The courthouse comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear in personally in this court for a plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under the what I know what you're trying to do is to try to use the sovereign citizen approach to this situation, and I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are in fact Matthew Neil Aldridge,
same argument.
then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is
Holy
what I'm
fuck.
going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Dude, he's got a
Is that an
glass
article
house
free
and
trial?
cabin. That's
To
$100
what?
right there.
Would that be a trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are.
Holy hell.
And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a possible way the jury wants? If you put a notice up there saying tonight, if we don't need you tomorrow, but we need you on February the Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry,
July 15th.
July 15th.
Aluminum.
All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place and his case will be set, will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
That's one way to do it. Did you see what happened there? That's just great. That's one way to do it. Oh, bullshit. Yay. Let's see. Judge revokes entitled Karen. I don't understand your stupidity. Mama's gonna go off on son during plea. Judge Boyd. Oh, there's my wife. Judge slams defendant who prayed on the helpless with a surprise sentence she was not expecting. Ooh. All right. give it a shot. I haven't seen this one.
Oh,
Turpin.
please don't do
Ms.
this.
Turpin, you are an incredibly poor risk.
I've
Going
never
to
done
jail.
this to
Hey,
anybody
don't talk over
before.
me. Don't talk over me. Versus Patricia Ann Turpin. It's case number 2023, CR 486. Amber Norris appearing for the state of Kansas. James
Damn.
Watts as defense counsel. Defendant Patricia Ann Turpin now appears at the court security Zoom location at the Judicial Center. Ms. Turpin, you were late to your
I
sentencing?
went to the other building. I didn't know which building to go to, and I ended up in the other building. That's why I was late.
Ooh, I want to make this
All right.
one work.
I don't think there's been court held in that building for 21 years.
I've never been to court here ever. I
Well,
had
you're
no
here
idea.
now.
There we go.
This matter comes before the court at this time for sentencing. Docket notes from June 18th indicate that the defendant pled guilty to count 3,
Relocated.
computer crime, a level 8 felony. A pre-sentence report was ordered. Sentencing originally set for August the 12th, subsequently rescheduled to today's date. This court has received an updated pre-sentence report compiled by Ryan Smith, pre-sentence investigator, who is part of this meeting. I trust each attorney has received the updated report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in the report?
I did receive the update, Your Honor, and no objection.
Any objection to criminal history by the defense here, Mr. Watts? Mr. Watts? You're muted.
Your Honor, no objection to the criminal history score.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score H, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Turpin case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, sir.
Ms. Turpin, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing?
No, sir.
Court proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Very well. Are there any victims or members of a victim's family who desires to address the court in relation to this sentencing? Who is Deborah's iPhone? Or Jacqueline Green?
Your Honor, Jacqueline Green is the victim witness coordinator in the office.
Okay, all right, fair enough. And there's no family members with her?
Not that I'm aware of. And Your Honor, I'm not sure who Deborah's iPhone is.
Is there someone whose screen name is Deborah's iPhone who wishes to address the court in relation to this Turpin sentencing? I would just like to have a yes or a no.
No, I do not need to address. This is Deborah, victim's daughter.
Okay, did you wish to address the court?
No, thank you.
All right, thank you. At this time, then, the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Turpin, beginning with Amber Norris on behalf of the state.
Your Honor, state would be recommending for the felony crime of computer crime. The court follow the presumption and assign defendant to 9 months in the Department of Corrections. Defendant would be able to earn 20% good time credit and would be subject to 12 months post-release. Defendant has earned 2 days of jail time credit. And Your Honor, this is a presumptive probation matter based on the crime and defendant's criminal history. So I ask the court assign her to 18 months community corrections probation with all standard and PSI recommended probation conditions, including a drug evaluation, no contact, and Your Honor, this is a community corrections case, so the court will need to assess standard probation and costs of the case, but then also the community corrections fee. There is restitution in the amount of $1,305.44.
Whatever
Some of that
happened?
goes to the victim's
They're
family and
asking
some of
for
it goes to
probation.
the bank. We'll make sure that the dollar amounts are specifically
the
set
problem.
out in the journal entry. Mr. Watts is
Fucking
appointed, so the
dang.
court will need to address court-appointed attorney's fees and the bid's application fee. And Your Honor, I don't think I have any further recommendations for the court at this time.
Very well, Ms. Norris. Mr. Watts, your recommendations regarding an appropriate sentence?
Thank you, Your Honor. Your Honor, we join the state's recommendation there in keeping with the plea agreement. I
Hamburger
believe
helper,
join
man.
the recommendation of the mitigated 9 months with the post-release and probation durations and good time credits as noted. We likewise have no objection to the restitution that is set out in the PSI. I don't know that I have a whole lot else to add, Your Honor. Thank you.
Your fees and the representation of this client?
This is billed at $1,000 to bids. Or will
Thank
be.
you. At this time, the court will address the defendant, Patricia Turpin, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Turpin?
I just want to apologize to the victim's daughter. I'm very sorry for what I did, and
Okay.
I really just want to say sorry to her.
Right. Any other statements for the court, Ms. Turpin?
No.
Very well. Court will pronounce sentence in this case at this time. Court hereby establishes count 3 as the base sentence in the case for the offense of computer crime, a severity level 8, non-drug, non-person felony, in which the defendant has a criminal history score of H, thus placing her in grid box 8H. Court hereby sentences the defendant to a term of 9 months in the custody of the Secretary of Corrections, the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would
9
be
months in
subject to
jail.
12 months of post-release supervision. No fine is imposed on that count. Court does note that in grid box 8H, this would be a presumptive probation case under Kansas law. There does not appear to be a special rule application here or a motion for departure to disturb that presumption. The court will grant the defendant 18 months of initial probation term to be supervised by Community Corrections. Community Corrections supervision is deemed appropriate due to the high risk score on the risk needs assessment that was conducted in this case. Conditions of that
9
probation will be to report to an
What did she
officer as
do?
directed, observe all laws, obtain a substance abuse evaluation within 45 days of today's date, and abide by the recommendations of that evaluation. She shall not possess or consume alcohol or illegal drugs while on probation. At her ISO's request and at her own expense, submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to any program requirements, gain and maintain employment successfully throughout her probationary term,
Nice.
notify her ISO of any change in employment status, residence, telephone number, or email address within 48 hours of any such change happening.
All right. What
Have
was
no
I
contact
doing?
with the victim in this case or members of the victim's immediate family. She shall submit her DNA to the KBI data bank and be responsible for the $200 cost of the test, abide by any curfew or travel restrictions imposed by her officer, follow all standard conditions of probation, not have in her possession firearms or dangerous weapons, and avoid disreputable characters and places. The defendant shall also make monthly payments on her obligations owed to the court, which would include a felony docket fee, felony probation fee, community corrections fee, the $200 DNA fee, and a bids application fee of $100. Attorney fees are waived, as the court will also be ordering this defendant to pay $1,305.44 in restitution to the victims in the case, as their interest may appear. Or again, will require $200 a month minimum, starting.
All right. I really want to eat the rest of this, but I need
in a
for
month to be
tomorrow.
determined by the court.
That's not enough, though.
Ms. Turpin, there's one other order that the court wishes to consider in this case. This court unfortunately has to see many cases where vulnerable people are exploited by others. I wish it was not so prevalent. However, this needs to stop. You are not new to the court system. You have, I believe, 3 prior property crime offenses on your record. So you're not new to this, and yet you exploited this helpless woman who was the victim in this case. And the court does have discretion, despite the fact that the legislature has determined you're not a prison case, that the court's up to 60 days in the county jail as a condition of probation. And that's exactly what the court's going to do here, Ms. Turpin.
Oh, yeah.
Please don't.
The court is going to order you to serve 58 days more because you've got 2 days of jail time credit against that sentence.
Can we schedule it?
Starting immediately.
Oh, please don't do this.
Ms. Turpin, you are an incredibly poor risk.
I've never done this to anybody
don't talk
before.
over me. Don't talk over me. You're an extremely poor risk to show up in jail on any type of schedule because
I promise I will.
You couldn't even make your sentencing on time today. Further, last time you were
other
directed
building.
to
I've never
appear
been there
at the
before.
Judicial Center and you didn't. Look, we're not going to talk over each other. I've made my ruling. You're not going to cry your way out of it.
Oh, yeah. Please.
All right.
I got my grandkids outside.
All right. Are you done, Ms. Turpin, so that I can complete your sentencing? Again, the court has announced 2 days of jail time credit. At some point in the future, Ms. Turpin, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any question about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, defendants have a right to appeal their conviction to an appellate court having jurisdiction. And if defendants are unable to pay the cost of an appeal, they may ask the court to appoint a lawyer to represent them on appeal and that they be supplied with the transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you, the defendant, at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, I wanted to ask you, of all of the financial assessments you were asking the court to impose, has the court covered all of those?
Yes, Your Honor, I believe so.
All right. Mr. Watts, is there anything further from the defense side that the court still needs to address?
I don't believe so, Your Honor. Thank you.
All right. The court is going to order Patricia Turpin into the immediate custody of the Butler County Sheriff's Representative
Judge, please, my
until her custody can be transferred to the Butler County Jail to serve out 58 more days.
Please don't do
this. And Judge.
Okay, it's 658 fucking days. Really? She's acting like she got 58 years. Grow up, lady.
What month did you want the payments to start?
Crimes.
Yes, we do need to come back to that. In light of the fact that she's going to be incarcerated essentially through September and October, of course, not realistically going to expect her to make payments during those months. So the court will start her payment obligation as earlier announced for the calendar month of November of 2024 and each subsequent month until her obligations are paid in full. All right. I think the sentencing proceeding is concluded at this point. Mr. Smith, thank you for your work on the case and your appearance here today, Ms. Taronis. Ms. Taronis, she's a little bit emotional right now. Do you still want to have a session with her?
Yeah, I'd like to try if I could, please, Your Honor.
All right. So I'm going to go ahead and recess this proceeding. Ms. Turpin should stay. I'll just direct court security. She needs to make contact with her ISO so she knows what to do when she gets out of jail.
Please, Judge, please.
All right.
Let me schedule this jail time.
If there's nothing further, the Turpin matter will be in recess at this time, and we can conclude the record and leave the Zoom meeting open for the ISO.
Hello. This is Attorney Mike Grevin coming to you from Chicago as usual. All right, I just changed the time for fun. I'm really here. We had Jay Regier Day today. I had a whole bunch of people. Speaking of which, I need to do my thank yous already. We have Natalie D. It's Natalie D's fault again. Mortimer Duke, but you know whose fault it really is today. Christopher Lakin. He made me a GIF or a GIF, however you want to say that. I still don't know to this day. I hear a lot of fights about it from Jay Regier, but then everybody sent me clips. So you tell me what you think about it.
Shut up, Mike. No one fucking cares. All right. Judge deports heinous monster. Oh, Judge Boyd. Judge Boyd is a good judge. I can't say the man because she's a woman. There's something about her stare, like just watching her when she does this thing where she'll just sit back and let people talk their way into a hole, and the way she stares at them would, I don't know, it would scare the hell out of me if I were. She is.
All right,
no
court is
fucking
calling.
nonsense.
2024.
No nonsense. Like, by the book. Like, she don't fuck around, man. She's one of my favorite judges.
CR 47.
And she's highly intelligent. Like, she knows her shit. She's very, 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 very smart.
6-3. State of Texas versus Francisco Ricardo Sotelo Baez. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Matthew Finch for Mr. Sotelo.
And are you Mr. Sotelo Baez?
Yes, Judge.
All right, we're here for sentencing. You entered a plea in this cause. Let me find. On July 30th of no contest and applied for deferred adjudication. According to the plea bargain agreement, the state is asking that your punishment be assessed at 6 years in the prison, and they're silent on your application. There's to be no contact with the complainant and an affirmative finding of family violence. All right, no PSI was done in this case. The court requested a criminal history. Any objection to the court reviewing the criminal history?
No objection. Thank you, Your Honor.
You're on the top page is the Bear County, but then the latter is the TCIC and CIC.
All right, thank you. All right, court has reviewed the criminal history.
Thank you, Judge.
All right, defense state is silent. Do you have any witnesses?
I do not, Your Honor. I anticipated having some of his family members here. However, they're sick right now, so they're not in court today.
All
However,
right, do you want them to appear by Zoom?
there might be some interpreter issues and everything else, Judge. I don't know. Okay, Judge, my client has informed me that it might be easiest just to proceed today, that it would be difficult for them to be able to do that.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Francisco Ricardo Sotelo Baez.
All right, sir. Your attorney has told me that they don't have witnesses present. Off the record for a moment. Excuse me, Deputy Laura, could you move them to the end? All right, we're back on the record. Mr. Bias, if you want, the court will have your family members or whoever you wish to testify to appear by Zoom. We can make that arrangement if you would like to. Otherwise, we can proceed.
We'll proceed. I really talked to my mom, but they're sick right now. My sister's sick right now. They said it was a virus, and my mom doesn't really know how to use the phone like
I
that.
like that one.
All right, so defense, if you've had a chance to talk to the witnesses, if you want to make a proffer to the court of what they would say, the court will take that testimony.
I can, Your Honor. When in my closing remarks, I can do all that.
All right, any questions for your client?
Mr. Sotelo, we're here today. Would you like the court to grant you the deferred adjudication that you'd applied for?
Yes,
And you understand she has the discretion to do that?
yes, sir.
And you understand that you would be obligated to follow any conditions that the court imposes on you?
Yes, sir. I do understand.
And you understand you have several other things.
You need to speak up so the
Yes, I understand. Sorry, Judge.
And is it your intention to do what you can to be compliant if the judge grants you that probation?
Yes.
You've accepted responsibility by entering a plea before this court. Do you, can you kind of the right way? Explain to the court what you're asking for today.
I would really want you to give me a second chance to redeem myself. I just had a newborn that was born on June 23rd. I want to be out there for my family. I'm 23 years old with 5 kids. I have 5 kids right now with the same girl. I really want to be part of their life. I don't want to go away to prison and show my kids that I could be a role model for them. And also, I help my mom and my dad out to pay rent as well. I'm always working for them too, take care of my little brother también. And I would really want a second chance. I promise you I won't mess this up. It's my first felony I have, and I'm not gonna mess this up. It's my first and last felony. I'm again. I've been trying to change my life around, going to church and in jail. I really want to see if you could please help me out with this. My bad, my English is a little, I know more Spanish, but.
Oh, no, do you need, here's the thing. Do you need an interpreter? Because I want to make sure.
I understand, it's just that English, I speak it too, but right now, because I'm in front of you, I get a little bit
Are you having
nervous.
problems?
Well, let me just tell you,
I can
there's
get
no
you an
need to be nervous in front of me. There's no need to be nervous about your English. I always say people who speak more than one language are very intelligent because learning a second language is very hard. And people
Especially
tell me
English.
that the English language is one of the hardest because you have two TWO, TO, TOOO, and it's all pronounced two. So if you want an interpreter to be brought down, it will take us probably 5 minutes to get an interpreter here. If you would feel more comfortable speaking in Spanish, we can have an interpreter to come down. It's not a problem.
That's fine, Your Honor.
Okay.
I'm good speaking to you. My bad, it's just that I really get nervous.
No, no problem. Any other questions?
You got all pass at this time.
All right, any questions?
No, no questions from the state, Your Honor.
All right, I have some questions.
Yes, Your Honor.
All right. So the child you hit, how old was that child?
She's 2 years old.
2. All right. And you say she, but in the police report, it says son.
Yeah, well, I have 3 daughters and 2 sons now.
All right, so the person that
That's
you
my
hit
son.
in this case,
It's a he.
I'm sorry?
It's a he.
I'm sorry, what?
It's a he.
All right, and how old is he?
He's 2 years old.
All right, so why is it in the police report? This is what they said. You texted his mother and you said, you're not going to like what I just did. I hit your son. Why are you calling the child your son?
Because,
Yeah, that's kind of weird.
well, it's our son. It's our son. It's my biological son.
Sufficient.
But why
power.
you just,
Yeah, it's baby's. He's mama's boy. So
oh, he's a mother's boy.
he's mama's boy. So
Okay.
he's always. I told her. She told me the same with my daughters because my daughters are daddy's girls, you know.
Okay.
And
So why are you hitting a 2-year-old? What was the reason?
I had a lot going on today. I had got into a fight with my family members. My wife was in the hospital.
So you get in a fight with your family members, your wife is in the hospital. So how does that translate you to hitting a 2-year-old?
I did wrong. I know I did wrong.
No, I mean, what, I'm trying to figure out what was the cause. I wasn't there.
Well, what happened was that with my son, I'm a little bit tough with him because basically he was my only boy. He was surrounded by girls, and
You're a little bit tough with the 2-year-old. Okay.
yeah, and I would want to play with him. I would want to play with him with the cars. I'll buy him cars. I'll buy him robots, boy toys. But he didn't want to. He wouldn't want to play with toys.
Okay. He doesn't want to play with toys. What does he want to play with?
He wants to play with Barbies.
All right. So he wants to play with Barbie dolls. So that was your issue with him.
And then my wife and my mother will tell me my son was gonna be gay.
Mm-hmm.
And for me, feeling that way, my first son to be gay.
So your thing is, let me hit my 2-year-old because people are telling me he's going to be gay.
That was my first time laying my hand on him.
No. I'm just trying to get into your thought processes. So people are telling you that your son's going to be gay because he doesn't want to play with robots. So let me ask you this. Would G.I. Joe, those toys, because those are dolls, would that be an issue?
Or G.I. Joes.
Oh, okay. I'm showing my age. Nobody, Snake Eyes? What? Well, you do know they have Ken. For example,
I probably wouldn't admit
Ken.
all that. Just
That's a doll. That's
probably
I
wouldn't
guess
admit
that's
all that.
Barbie's sometimes boyfriend, or maybe it's sort of like undecided. I don't know if they're together or not. But Ken is a Barbie. So how would you feel about your son playing with the Ken doll? You just don't want him playing with dolls.
I didn't want him playing with dolls.
Oh.
My daughters have like little kitchens and like dressing dolls and all that.
And so he would play with the kitchen set.
He would play with the kitchen set and all that.
All right. So
And
let me.
I'll buy him like trampolines and like a little soccer field, and he didn't.
Yeah, I want to play
he didn't wanna
soccer.
play with that.
I don't want to play soccer either. So he don't want to play soccer, and he plays with the kitchen set. So I guess males who are chefs, that's like a girl job, right?
Well,
I mean, wouldn't that be considered a gay job then if you have male chefs in the kitchen?
She's got a point though.
I'm like, all these men who are walking around out here being chefs.
What do you mean
You're
insufficient
telling me that they're
power?
gay.
yeah.
So then you hit the 2-year-old and you cause his nose to bleed. And then it says the victim had injuries, bruising and swelling on the face. And they say you sent a text message and said that you hit the victim 4 times in the face by slapping him. In what world is it okay to slap a 2-year-old in the face? What did you think you were teaching him?
Nothing.
Like to be afraid of you?
No, not really.
I mean, did you think the 2-year-old was not going to be afraid of him? Because 2-year-old, I don't think he's 6 feet tall. You're standing over him, slapping him. Did he cry when you slapped him?
Yes, Your Honor.
Told you she was
All right, when his
smart.
nose is bleeding, you continued to slap him. Did he continue to cry?
Well, I don't really remember his nose bleeding on him.
Did you get him some tissue? Did you clean up his face? Did you apologize?
End of his face. I spoke to my wife. I apologized to her.
No.
And I
Did you apologize to the 2-year-old?
Yes, I heard that.
And did you apologize to your daughters if they were at home and witnessed that?
And my daughters were in the other room.
They were in the other room?
Yes.
So you think they don't hear him crying? Do you have like a west wing and an east wing to your house, like Dallas? Like South Fork?
I apologize to all the kids, Your Honor. I know, I have an older daughter that she's 5. And
All right, it says here that you stated that the mother says that you're always unnecessarily hitting or disciplining the victim due to him being more feminine and wanting to toughen him up. So you think you beat up a 2-year-old by toughening him up, because that's what this is. You beat up a 2-year-old. You beat up a 2-year-old.
He was 2? What the fuck are you doing?
And then I'm looking at your criminal history. You have other assaults. Who is the other family violence assault against? Was that against the mother of your children?
Yes, it was again.
All right. So why do you continue to hit people that you claim that you love?
Because I wasn't around, man.
No, but why are you doing it? I don't understand.
I wasn't married. I don't know if I can say it. But
Oh my God. What are you talking about?
What I can tell y'all on this case, I don't have the trial court
power
certification of
for it.
defendant's rights to appeal. It's
Oh my
missing.
God. Frustrating.
I'll re-execute it, Judge.
All right. Could you grab that for him, please? Yes, there's something you wanted to say?
yeah, look, it's because I was in drugs, and I had tried a new drug that I had never tried before. That's what made me like it.
Well, here's the thing. According to what I'm reading in the police report, this isn't the first time that you've hit the 2-year-old, according to the police report, right? Is this the first time you hit him?
Yes, sir.
Not according to the police report. And it says that you're always disciplining him unnecessarily because you're trying to toughen him up because you think that he's gay.
I'm not thinking he's gay. But my parents, my mom.
Oh, I'm so sorry. You know what? Here it is. I found it. Thank you. And then what kind of grandparents does he have in his life, if what you're saying is true, where they're like, toughen him up, we don't want a gay grandson? What kind of nonsense is that?
Oh, he's grandma's boy too.
So in
But
your
it was just to get me mad.
well, here's the thing. In your son's 2-year-old life, he's already had trauma and drama caused by you. So now he thinks men gonna beat him up. Any other questions?
No, Your Honor, just argument.
All right, I'll hear argument.
Your Honor, obviously the facts are not the best. My client did make some pretty grave errors in his dealing with his 2-year-old son. He's learned that as in our conversations, and as I said, in jail since this happened.
Finally. No, what the?
Judge, his family has been involved. I think they would be a great support system. I think they understand the significance of what has happened. I'll point out that my client is 23 years old and has 5 kids, Judge. Probably hadn't had any formal training. If there's drug issues, if there's domestic violence issues, there's a lot of different programs within the probation department, like the BIP program and drug counseling and TAP evaluations that can focus on that to ensure that he has a chance to be successful on probation, Judge. In addition, Judge, my client is not a citizen. There's been a Padilla consultation with the Managed Assigned Counsel program. And knowing that my client is still before this court and asking for some leniency, but Judge, he also has a pending ICE hold. It's a fact. So
Sorry, a pending what?
ICE hold, Judge. There are proceedings going on. He will visit an immigration judge after this is done. So if he is granted probation, he still has that to deal with, Judge. But we're just asking that he be given an opportunity to learn from his very poor decisions that he made. He's been very straightforward with the police, with all the reports, and with this court today. Whether it's right or wrong, he clearly needs to learn to how to raise children better. And I think the programs that the probation could offer in any reasonable condition that the judge would want to impose would be able to assist him in learning so that this cycle doesn't happen again. Judge, but we're asking for a stretch. We're asking for a little bit of mercy. My client is hoping to get probation. We'd ask that you consider that. He's got a lot of work left with him. His decisions that day impacted his family, not only because of this case, but everything else, their entire lives and going on, and even my client's ability to possibly remain in the country. Judge, with that, we'd ask that you take that into consideration and give him that chance. And he understands that if he gets deferred and messes it up, he has the full range of punishment. So he understands that there could be an even more significant punishment if he doesn't change his ways and engage and cooperate with probation and whatever orders this court makes.
Okay. So you said you have 5 children. So I see here it's Rodrigo, Delilah, Veronica, and Laura. Who's the other child?
But he was just born on June 20th.
What's the name?
Tadeo.
How do you spell that?
T-A-D-E.
T-A?
No, T-A-D-E-O. Ricardo Sotelo. He was just born on June 23rd.
Okay. All right. Is there anything else?
No, Your Honor.
All right. The court is going to find you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with, there's to be no illegal reentry to the
6
U.S. and there's to be no
years.
contact with minors. I'll order the therapeutic community. Maybe they can help him. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. Yes, you have a question? You have a question or no?
I just wanted to see a second chance.
I'm sorry, what?
I just wanted a second chance to redeem myself, please, Your Honor.
All right, we're off the record. This is what I want you to understand. I internalized everything that your attorney presented, and your attorney presented some great arguments. In your past, you have assaultive behavior against the mother of your children. Probation for that, they would have given you the BIPP course. It's legally required. You have learned nothing. Basically, you beat up a 2-year-old because you think your 2-year-old is gay and you want to toughen up a 2-year-old. He's 2. It's like, imagine yourself in a boxing ring and your opponent is a 2-year-old. The 2-year-old doesn't stand a chance. The 2-year-old is gonna, lose every time. You hit him in the face, give him a bloody nose, and according to the police report, after you hit him in the face, I'm sure he's crying, and you continue to hit him 4 more times. Then you text his mother, you're not gonna like what I've done. I hit the 2-year-old. And then the mother in the police report and everybody in the police report tells me, you discipline him unnecessarily because you think he's going to be gay because he likes to cook. Go tell Wolfgang Puck. You know what? What if Wolfgang Puck's family would have thought, Wolfgang is going to be gay. We're not going to let him cook. Right? Have you ever cooked your own meal? Are you gay? Then why are you beating up on a 2-year-old because he likes to cook? To me, that would be a great thing because everybody is out here, you, having children that you can't take care of. You're 23 years old and you have 5 children. It would probably be nice if you had a teenager or somebody in the house who loves to cook and you encourage that. Then guess what? That's no cooking on your wife's plate. It's off the table. You understand? You are not to have any contact with minors when you're released. You're not allowed to come back to the United States unless you're here legally. And I can't stop you from having children, but if you can't financially take care of your children, if mentally you're not ready, which it appears to me you're not ready, if you're going to be violent, then you shouldn't really be around children. You shouldn't be having more children. Do you understand? All right, good luck to you. Delia Ochoa.
Can I get another chance? Even though I know they're all criminals, they all, did something or whatever, it's still hard to hear someone's well, for some people, because that woman that was like, oh, please, please. It's like...
Hi, this is Attorney Mike Grevlin coming to you from Chicago, as usual, and I have got a treat for you today. This was sent to me by...
Mike, I'm talking. Except for that last one. She took advantage of a kid and just... Conspiracy theory Karen. Hell yeah.
I'm wrapped up. If you don't get it by now, then I guess I guess you're not going to get it.
All right, good afternoon. CV 24-5566, Yolanda Brommer versus Heather
Electricity.
Godwin. Mr. Akhtar has
Electricity.
appeared already on behalf of the plaintiff, and Ms. Godwin has appeared already pro se on
God.
behalf of herself. That's great.
So they
Ready
all
to
need
proceed. This
electricity
is
except
a
for
de novo appeal. I see that there was a late filed
Great.
motion to quash. There's not going to be a quash on a de novo hearing. You are bound and limited by your pleadings in this case. So whatever was filed in JP court and any other amendments that were filed in county court, those are the ones that the court will be considering, and no other legal positions because you're bound by the pleadings that you filed.
I'll be giving a brief opening, Your Honor.
Okay, then Ms. Godwin also will have an opportunity to do that as well. All right, Mr. Akhtar, you may proceed.
Okay, Your Honor, before the case in chief, we did file on November 7th a sworn motion for writ of possession because the defendant, Heather Godwin, the tenant in my client's home, did not pay November rent into the registry of the court. I also called and checked with the clerk yesterday, and again, that still seems to be the case.
Okay. All right, thank you. So right now I have before the case in chief, there is a motion for an immediate writ of possession for to comply with the justice of the peace order, and actually also not local rules, the rules requiring monthly payments to be made in the registry of the court while a case is on appeal.
Okay.
Mr. Akhtar has
Hopefully this
indicated
will
that
work.
the month of November has not been paid. I note that
What the
there was
fuck,
2050
dude?
in the registry as of
There's
October
not
18th.
inefficiency.
So,
power.
Ms. Godwin, did you file any
What are you
other
talking
funds
about?
into the registry?
I did not put I do have the rent.
There is enough.
However, because
Oh my
the
God.
rent payments are made pending appeal, if I did not win this appeal today, I didn't, those funds would be gone and I wouldn't have the funds to find another place to live immediately.
Okay, I
do
understand it.
Okay, so it was a formality and just basically, you
Understand.
Thank
I understand. And while I am very sympathetic toward that, I have to follow the rules, and the rules say if the party doesn't make those registry payments, I don't really have any discretion. I have to go ahead and grant. So I'm going to grant the 510-9C motion for an immediate writ of possession to be awarded to the plaintiff, granting them ownership and possession of the I'm not granting them ownership, they already have ownership, but possession of the property. So let's go to the merits of the case.
As I understand it, Your Honor, sorry to
Ma'am,
interrupt.
this is not a time for you to interrupt me.
Thank you.
Okay. All right. So we're now going to go to the main portion of the case. Plaintiff, you may provide your opening statement. Then Ms. Godwin will have an opportunity to give an opening statement as well.
Okay, to make it very simple, my client, Yolanda Brammer, is the owner and landlord of the rental property that's identified as Croydon Loop, Austin, Texas. She and Heather Godwin, who herself is a licensed attorney, although she calls herself pro se, entered into a lease in June of 2022, and everything was going along fine for $2,050 a month rent until June of this year, when she simply stopped paying. June, July, and August were unpaid. We went ahead and served a notice to vacate August 22nd. And as you'll see, the notice to vacate, it complied with all the statutory requirements. It was posted, it was mailed, and just for completeness, it was also emailed to her. She, of course, did not vacate. And so during the pendency of the case, she also did not pay September. She did, after the judgment was obtained in JP court, she did pay October rent in order to make the appeal, but she did not pay November, as we just discussed. So we're going to be seeking possession, and we're going to be seeking 5 months of unpaid rent, which comes out to a total of $10,250, plus my attorney's fees.
All right. Thank you very much. All right, Ms. Godwin, your opening statement.
My opening statement is that I am appealing this eviction based because it's not for a non-payment of rent eviction. The eviction, Miss Brammer did not evict me because I did not pay the rent. She had granted me extensions, and we had a history of extensions, and she evicted me because of retaliation for my taking advantage of rights that are granted to me under the rent contract, and also retaliation for my requesting repairs to the residents. I'm also requesting that if as I understand it, I am entitled to, if I get the funds to the court today, then the writ of possession is dismissed. The motion for writ of possession is dismissed if I have the rent today to put into the court registry. However, like I said, that provision is only for the pendency of the appeal, which is wrapping up today. That's my opening statement.
All right, thank you very much. All right, Mr. Akhtar, you may call your first witness.
I think I can do this simply by calling Ms. Heather Godwin, the defendant. Okay, Ms. Godwin, I'm putting up on screen what we've submitted and marked as Plaintiff's Exhibit 1. Okay, and do you recognize this as the lease that you signed with my client?
Can you scroll down, please? No, the lease that I have does not have the irregular font in that fashion. I don't know what happened to the formatting to that lease, but that is not the PDF that I signed.
Okay, well, despite the formatting, do you have any reason to believe that the substance of this lease is not the lease you signed?
Based on my experience with you and Ms. Brammer, yes, I have reason to believe that that is probably not the document that I signed. Do I agree that I agreed that I signed the lease that said I would pay $2,100 a month? And then I signed, and then we modified the terms of that lease that I would pay $2,050 a month and handle my own utilities. I will agree to that, but I'm not going to authenticate that document right there because it's not what I signed.
All right, in that case, fine. I'll just put that down. I will go ahead and open up what I've marked as Plaintiff's Exhibit 2. This is what we've submitted as our rent ledger. Do you agree that you did not pay rent in June, July, August, or September of 2024? That's a yes or no?
I did pay, yes, I did not pay June through September.
Okay, so at the rate of $2,050 a month, that comes out to $8,200 of unpaid rent, correct?
Correct.
Okay. And as we've just talked about here, you've also not paid rent for the month of November, correct?
Correct.
So that would add up and actually become $10,250 of unpaid rent, correct?
Correct.
I'm going to put up on screen what's been marked as Plaintiff's Exhibit 3. Do you recognize this document, Ms. Godwin?
I do.
This would be the notice to vacate that was served to you on August 22nd, correct?
Yes.
Okay. And it was sent to you by, do you remember receiving it by postal mail?
I did receive it.
Okay.
I have no objection to it.
And it was also posted same date, August 22nd, that being a picture of it being posted to your door in an envelope which said important notice, correct?
It was.
Thank you. Move to admit Plaintiff 3, Your Honor.
All right, I think I heard her say she didn't have any objection.
The only other exhibit I have for you then is Plaintiff's 4, which I'm putting up on screen. Do you recognize this document, Ms. Godwin?
Yes, I do.
Okay, this would be a post that you put on your own Facebook page, correct?
Yes.
Okay, and in which you actually didn't show up for the JP court and you let us go ahead and get the eviction by default even after you requested a jury trial. And you actually said the words, "I'm letting my landlord and her attorney take the default eviction today. They can sit in traffic. There really is no defense in justice of the peace court for me." Those were your words in your Facebook post, correct?
Yes.
Okay, so you admitted in your Facebook post that you had no defense to this eviction case.
Are you asking to admit it?
I'm not answering your questions. I've asked you a question. You admitted in your Facebook post that you had no
I
defense
admitted
to the
that
eviction
at that
case.
point in time, I did not believe I had a defense to the eviction. I admit that.
Okay, Your Honor, move to admit Plaintiff's 4.
I object to the relevancy.
Okay, that's overruled. Plaintiff's Exhibit 4 is admitted.
Very relevant. What are you talking
In that
about?
case, I have no further questions for this witness, Your Honor.
Ma'am, would you like to testify directly, or you want to wait until your case in chief?
I'll wait till my case in chief.
Okay, thank you, ma'am. Mr. Akhtar, you may call your next witness.
Okay. I will go ahead and call up my client, Yolanda Brammer.
Give me 1 second. I think I can bring her back. 1 moment.
All right, there we go. All right, let's go
I
back
had to
on
go
the
into
record.
settings. I apologize for that.
Let's go on to the record. Mr. Akhtar, you may proceed.
Okay, Ms. Brammer. I'm going to go ahead and put up what's been marked as Plaintiff's Exhibit 1. Do you see that on your screen?
Second, I do, yes.
Would this be a copy of the month-to-month lease? Then, Your Honor, I'd like to admit this as Plaintiff's Exhibit 1, the lease.
All right, any objection?
Yes, that's not the lease that was signed. Objection.
All right. All right, so Mr. Eckhart, do you have a response to the objection as far as the authenticity of the document, the originality of the document?
Yeah, I mean, my client has testified that it is the lease. It's just a formatting error in the way she printed it off and was able to get it to me.
All right, keeping in mind the objection of the defendant, I'm going to go ahead and admit Plaintiff's Exhibit 1.
Okay, thank you. And Ms. Brammer, you've had to hire me to try to evict Ms. Godwin, correct?
That's correct.
And what hourly rate are you paying me?
$300 an hour.
Okay. Thanks very much. I have no further questions for this witness, Your Honor.
Okay, Ms. Godwin, do you have any questions?
I don't.
All right. Thank you, ma'am. You're excused. Mr. Akhtar, next witness.
Okay. The last witness will be myself to testify to attorney's fees.
All right, you may do so. Thank you.
Thank you. I'm putting up on screen what I've already submitted to the court in box as Plaintiff's 5. I just have to say, by way of really brief preface, that Ms. Godwin has really bombarded not only the JP court, but also the county courts and also the district courts, and is also threatening to file in the federal courts with a number of different filings, which are all tangential to this
what a
case.
surprise.
I have done my best to conscientiously highlight only those attorney's fees that have to do strictly with the JP eviction and then this county court appeal. So
Shocker.
I am representing my client at the rate of $300 an hour. I was licensed in November 1st of 2000. That's a very reasonable and competitive rate and has been made necessary by the defendants' multiple filings and all kinds of creative attempts to try and stay in this house while paying no rent. It began in August 20th of 2024 when I conferred with my client, and then we drafted the notice to vacate and proceeded with the petition for eviction. And it continued through the months of September, October, and now this month. When it comes down to the end, I've totaled up that up to and not including today, the total of attorney's fees has been $4,230.76. That's strictly limited to the eviction and the appeal of the eviction. That does not include the court costs. As far as today, I will calculate that there's been an additional half hour of attorney time. So again, at my rate of $300 an hour, that's another $150. So if we were to add that, that becomes $4,380.76 in attorney's fees that we're asking the court to award on top of the unpaid rent as well as possession. I seek to admit Plaintiff's 5, Your Honor.
Any objection?
No objection.
Thank you, counsel or litigant. I'm not sure what stage you want to be on, but thank you. Plaintiff's Exhibit 5 is admitted.
Okay. With all of that, then, Your Honor, plaintiff rests.
All right. Thank you very much. Plaintiff is rested, and now, Ms. Godwin, you have an opportunity to present your case in chief and present any witnesses that you'd like to offer.
Okay. I will.
Nice.
This case concerns
Are you going to hold on? Are you testifying? Are you going to call yourself to testify?
I'm calling myself to testify.
All right. Thank you, ma'am. All right. You may testify in narrative form since you're representing yourself, beginning, I guess, with your name, and then you can proceed from there. Thank you.
My name is Heather Godwin. I am a tenant here. I have been a victim of trafficking for a very long time.
What's that got to do with not paying rent? No offense, even if it is true, what does that got to do with anything with paying rent?
Yolanda Brammer reached out to me when I was
I like her long
in
pause too.
my previous apartment and complaining about trafficking, and she offered to put me in this house. I was an attorney for her
something else, dude.
brother when I was working for Eric Willie, and I was having severe hacking issues when I split from Mr. Willie's firm. And I could not handle her brother's case well. And she called me and she said that she was unsatisfied with the amount of time I was taking, and that she was going to, and that her brother wanted to move the case along. And I said, I had no problem with that. I totally understood. And she said she would call me back. And she called me back about a half an hour later, and she said, everybody knows what's happening to you. And I was amazed, and because I kind of felt like I knew that people knew that what was happening to me. And she reached out to me and she said, do you need a place to stay? Are you in fear for your life? And I said, yes. And she said she had this place available and that her daughter had just moved out. And she was going to rent it out for an Airbnb, but I could stay here as long as I needed to.
I'm sure.
And so I came here.
$3,000
and I moved in
a month of rent or whatever it is. Right.
But and I thought that I was free from
You're not
everything.
fooling anyone.
But I was still hacked and my cases were still being messed up with, and I was complaining about that online. And I came back from being out one day and the batteries were out of my thermostat. So I was wondering how they got in. And that's when I realized that she had rented me a place that had no patio door lock. The patio door lock had been hollowed out like that. And so I called her up and I said, and so I'd like to offer Exhibit D6 into the record.
All right. Any objection to D6?
Objection to relevance, Your Honor. These are repair and remedy claims that have already been dismissed in JP court due to non-payment of rent.
Huh.
All right, I'll go ahead and allow
think
it.
so,
Defendant's exhibit 6 is admitted.
This is truly, I
Sent it to her and she said, oh, don't worry about that. My son-in-law did that. And I said, well, it's broken. And I said, I wanted to replace it. And she said, no, do not replace it. And I said, I can just replace the handle. I don't have to replace the door. And she told me no. So I put up a sucker, like one of those, like a sucker type hook onto the glass so the glass could not be opened. And I replaced the batteries in the thermostat, and I filled all the holes in the walls. But I was still being bullied online, and
hi, buddy.
Then and still complaining online about it because I realized that I was still in the same stuff. But at that time, I really believed Yolanda was an innocent bystander. Like she, through some weird circumstances of events,
oh my God,
she was being manipulated and used because she was my friend. And right now I am actually reading from defendant's first amended answer, plea and abatement and motion to dismiss cause of action that was filed in this matter on October 4th.
Damn, that was close.
And those were all handled by the JP court, correct?
Yes, Your Honor.
Okay. All right. So I just want to go through.
Understood.
Yeah. All right.
So
okay. Anything else?
Yes, and then on September 3rd.
Okay, lady.
September 3rd, 2023. I was very upset, and I told Yolanda that I wanted to put a fixed lock on the patio door so nobody could come in, but then I was just so hounded, and just they're never gonna let me go.
Bro, she is fucking
That's
out
what I
of
thought,
her
and so I
mind.
sent her a message, and I said, they're gonna keep on filming me, you know, and they're gonna keep on making money off of my nudity for as long as they can until I
Oh, do
can
you
flee
have
to where I can
proof of
protect myself, and they
those?
have no power. And she answered yes. Like, she admitted that
You?
it's happening. And for the life of me, I don't understand why I'm having to file all these things. I don't know. I don't understand how it is that all this litigation can be created around when there's this absolutely salient fact just right there in black and white. But I am still have to prove over gaslighting that this is occurring.
Lady, no one wants to see you
So
naked.
I stayed living here. I had a number of family law cases. I had a very large family law case that I thought was coming. I also
Nobody
I was also
wants to
suing
see you
who
naked.
I thought were the main
Did you hear that?
perpetrators in the trafficking issue. And Facebook is actually a part of that, so it was removed to federal court. That was dismissed, except for Facebook. Judge Pittman told me to sue Facebook in Washington, which I will. Or if I go and file suit if I leave here and go to New Orleans, I can file suit in another district court. I was sanctioned from filing again in Texas District Court. That's what I was sanctioned from doing.
That's unfortunate.
Not the circumstances and suing on the events of the trafficking. And I was not served with any slap lawsuits in retaliation for that suit as well, which should show you at least there's that level of civilization going on.
Dude, this gun is up.
And I'm also appealing the trafficking suit against Miss Brammer, because in that motion to dismiss hearing, the judge kept on saying appeal, 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 which opened up my mind to the realization that on the trial court level, much graft and much extortion and pressure occurs. However, when it comes to going to appellate court and the concept of having this fact pattern in black and white in the books for other attorneys and the whole world to see forever as an appellate court in the reporter, that's not going to happen. An appellate court is not going to look at this fact situation and say, oh yeah, that's okay. So,
ma'am, we're going to have to wrap this up. So is there anything else relevant to
I would like to also
hold on, stop talking for just a minute. I need to have any other evidence that you wish to present as to the lease and the payment under the lease.
I would like to say also that in January, I requested an extension on the lease for Miss Brammer. And she said, of course, you can have an extension.
She said you could stay there as long as you
I took advantage of that extension, and when I was able to pay her, I said, thank you so much for the extension. And she said, oh, you're welcome. And I said, I was afraid you were going to kick me out. And she said, oh, I'm never kicking you out.
Oh, that sounds...
And so what happened...
She's so dumb.
So what happened in June was that
So you like it, motherfuckers.
And I was not, at the time that I made this, what happened in June was the house significantly started shifting, and I started to have to take care and caulk and fill in holes, and then in late July, in July 25th is when I started covering myself.
Oh my God, lady. No one believes you.
I covered myself in the bathroom, except when I was behind the shower curtain, and I covered myself in my bedroom unless I was in my closet.
You know who she voted for, right?
That Miss Brammer said, hey, are you all right? She ignored all my texts.
That's what I try and tell people. Who do you
She
think
ignored
she voted
all
for?
my texts about, can I get the
I
extension?
should answer everything.
Will you please respond to me? Please respond to me. All the texts from June 14th about me talking about these are all my texts to her, and she does not respond, which is a facet of emotional manipulation, is withholding information and stonewalling somebody. On July 25th, I began to cover myself in the house. That's when she put it in. Call me. I called her. I tried to text her. I could not get through to her. I was still trying to contact her and talk to her.
Wow, he was
I hope
not
you're
easy,
doing all
actually.
right. Still, I'm covering up. Hey, are you okay? I'm still covering up. I don't want to
Yes, I
see
believe
you, Yolanda.
No one
I'm
wants to
still
see you
covering
naked,
up.
woman. God damn it.
And at that point, I thought it was the music industry, but I don't really know.
What?
I don't know. I just know it's happening. And then here she is on August 1st. I'm still
This
covering up.
lady's an
They're
attorney.
still saying, "Are you okay? Are you
apparently,
okay?"
that's what she says.
Because that's what's a hallmark of the abuse that's been happening
probably
to me.
an attorney,
is that
not
my
a,
protesting is
a lawyer.
something's wrong
There's a
with
big
me.
difference.
Something's wrong with me because
Between
I'm
an
not
attorney and a
allowing them to
lawyer.
film me. It's really insidious. And I think I'm one of the few people, I don't. So this is me explaining to her how I'm going to move. Can you please just, I'm going to move and sue people. And I'm here recounting our conversation with her. I'm recounting, Yolanda, this is what happened between us. And she's not responding.
No.
And I'm telling her Zach may have broken the handle, but you forbid me to place it. That's how they got in,
okay,
and
good.
that's negligence. I'm still giving her the benefit of the doubt that she's not involved. I'm still like, please understand what your place is in this. I'm going to have to sue you. She called me up. We got on the phone, and she said, "Are you okay?" And I said, "Yolanda, I'd be okay if you just give me the extension on the rent. Just let me know." And she said, "Well, I'm not calling about the rent. I'm not calling about that. Are you okay?" And her telling me that was telling me she doesn't care about the rent. She is calling me to see if I'm okay because I'm not exposing myself in here.
Oh, so just
because I'm
forget about
closing
the 10
myself
grand.
off and covering myself
'Cause I'm
off.
calling to see how you
And
are.
I said, you don't, and I said,
All right, man. We need to kind of wrap this up.
okay,
I've got
all right. Well, I'm wrapped up. If you don't get it by now, then I guess you're not going to get it. In response to that, in response to at that phone call, she said she'd have to think about it, and I still covered myself up.
She is off her
And
rocker.
the next day, she said, "You're evicted for non-payment of rent."
Okay.
Your Honor, it's just.
Anyways.
Can I
Hold
say
on.
something?
Yolanda.
No, you cannot. You
Okay.
cannot.
Okay.
All right. Mr. Ackbar, do you have any questions?
No questions for this witness.
All right. Thank you. All right. Ms. Godwin, you are you're excused as far as the witness goes. Are there any other witnesses you intend to call, or is that it? All right. I'm going to assume then we're going to move forward. Both parties have, I presume, rested, and we can do any closing statements, brief closings, if you wish to do those. Mr. Akhtar?
Yes, Your Honor. Quite simply, I feel badly for Ms. Godwin. She's clearly not well, but that's not my client's problem. Ms. Godwin is not entitled to just stay in her house rent-free month after month after month and just sue.
Yeah, she's not well.
Make a mockery of the court system by just suing case after case after case against everybody. She's admitted that she has not paid for 5 months of rent. That's $10,250 of unpaid rent my client has suffered. She's also had to pay me $4,380.76 in attorney's fees. that's through the end of today, for doing our best to just get Ms. Godwin out. She's filing every possible manner of thing to stay in, but none of it has to do with any defense for her eviction because of non-payment of rent. We're just asking for some finality to this. I know she's going to continue filing things, but she needs to be out of there.
All right, thank you very much. Closing statement is Ms. Godwin.
Yes, Your Honor, this is not a eviction for non-payment of rent. This is an eviction in retaliation. There's a case that's in evidence. It's Terrace Pines versus Laird, in which a tenant who was delinquent in rent complained about repairs needed to an apartment, and the appellate court found that it was indeed a retaliation of rent, even a retaliation eviction, even though the tenant was delinquent in rent. You can have a retaliation claim, and I have the elements of a retaliation in my answer.
Thank you. All right. Well, I appreciate the courtesy y'all have extended, although I understand from my staff that there have been numerous interactions with both parties, even a party that's represented by counsel. I'll just encourage y'all to continue to be pleasant as you deal with other court staff as you move forward on this matter. I'm going to rule in favor of the plaintiff. I'm awarding her possession of the property. I'm awarding back due rent, and
good for her.
Plaintiff has
Get her
requested
fucking home back.
$10,250, and I guess that doesn't include the $2,050 that's right now in the registry for the month of October. So in actuality, I'll award damages of $10,300 to account for that October rent, and then order that the clerk's office tender the amounts that are in the registry to the plaintiff as an offset for the damages. So then you get your $10,250. I'm going to award attorney's fees of $4,380.76 and court costs to the plaintiff. Because I'm already awarding an immediate writ of possession, I don't know if y'all want me to issue a supersedious bond in the judgment. I can do that if that's requested. Anyone want that? No? All right. Very good. All right. And with that being said, if you'll send us if you might already have sent us a proposed judgment, both on the main case and also on the immediate writ of possession, I'll sign those, and then y'all can proceed as you may, whatever you decide to do. But I appreciate the courtesies y'all have extended to me and my court staff. All right, and with that, y'all are excused, and I can move on to the next case. Thank you so much.
Thank you. Just one quick moment. So I uploaded the two different orders to the proposed orders of box. One was on the writ of possession, which also requested release of the $2,050 of October rent. The other one was not including that amount, and it was for the 5 months that we just discussed.
Okay. All right. Well, my staff will look at it. Thank you.
All
right. All right. Y'all be safe out there. Thank you. Y'all are excused. Thank you.
Crazy lady. Wow, she was a nutcase. Wow. She was fucking crazy. Wait, did I put one over another one? No, okay. Where's that fucking light that I had? Where are those fancy lights? Where the fuck did they go? No.
Hello. It's Tony Microphone coming to you from.
I'm wrapped up. If you don't get it by now, then I guess you're not going to get it.
Dude's wasted in court.
Didn't understand a word you're saying.
Is it working yet?
You're mumbled.
Is it working yet?
Oh, there it
No.
is. No.
Your audio is not your video.
Okay. Yeah, I've been on since 3:30. Yeah, I didn't know my video was working.
It doesn't count if you're not there when I call your name. You owe those officers that came by your house a debt of gratitude, or you'd be sitting in jail.
Yes, ma'am.
You thank them for coming by and making that public service to you.
Yes, ma'am. It's working now, ma'am.
I'm serious, Mr. Michael. You owe those gentlemen some gratitude.
For sure.
If they hadn't been willing to go by your house and wake you up, I would have just issued bench warrants.
Thank you.
All right, let's get
My
on.
video is working, isn't it?
Let's get on with the order of business here. You were supposed to be here at 1:30 and it is now 3:05, and you wouldn't even be here now if the officers hadn't gone to your house or wherever you are and woke you up. Apparently you're not at home.
Yeah, ma'am. Not until this court date, I hope.
Apparently they knew where to find you. So again, you're lucky in that respect. All right, we're going on the record now, sir. Are you awake?
Yes, ma'am.
Sure you understand what's going on, where you are?
Yes, Judge.
All right. We are on the record in 2023 CR 80 and 2023 CR 96, both captioned State of Kansas versus Jacob William Michael. The state appears by and through County Attorney Jill Gillette. Mr. Michael appears in person and pro se via Zoom. It is now 3:07 p.m. and he was to be here at 1:30. He called in and then apparently fell asleep and didn't answer. So the officers had to go by his home to try to find him, to wake him up. Couldn't find him, so they went to another location he might be at, and they found him and woke him up. This was a public service the officers did. They didn't have to, but they have saved bench warrants for Mr. Michael. Mr. Michael, you need to pick a location, stay seated, and keep your camera on you, please.
Yes, ma'am.
Sir, this is your first appearance in 2023 CR 80.
Dude, he is
In this
wasted.
case, the state is
He is
charging
fucking
you
trashed.
in count 1 with domestic battery that on or about the 22nd day of April 2023 in Greenwood County, state of Kansas, you did unlawfully and intentionally cause physical contact with a family or household member in a rude, insulting, or angry manner, the family member being this. Okay, keep your camera where I can see you, please. Thank you. As charged, this is a Class B person misdemeanor. There is a mandatory must serve 48 hours in jail up to 6 months. There is a mandatory minimum fine of $200 up to $1,000. Now the court can waive the jail time if instead you do a certified domestic violence offender evaluation by a certified evaluator and comply with all the recommendations of that evaluation. In count 2, sir, you're accused of disorderly conduct. The state is alleging that at that same date, you did use fighting words or engage in noisy conduct tending reasonably to arouse alarm, anger, or resentment in others, to wit, Aubrey Maxwell. This charge is a Class C misdemeanor. If convicted, you could serve another 30 days in jail and you could pay another fine of $500. In count 3, you're charged with criminal damage to property. the state is alleging on that same date, you did by means other than fire explosive, either damage or destroy or deface or substantially impair the use of property, to wit a cell phone, in which another, to wit Aubrey Maxwell, had an interest without her consent, and that the damage you did was under $1,000. As charged, this is a Class B non-person misdemeanor. You could serve another 6 months in jail and pay another $1,000 fine. Mr. Michael, do you have any questions about these charges or their possible penalties that I could help you with today?
No, ma'am. Other than the two last ones you said are new. I didn't get those ones until today. Or whatever. I mean, it don't mean anything. Just the others are new. I didn't understand what I had to do. But no, ma'am.
Mr. Michael, are you on any drugs today or alcohol?
No, ma'am. I'm sitting on the edge of bed and I can sit up a little bit.
Bro, you
You're still
are
what?
trashed.
I'm sitting on the edge of bed. On the edge of a bed, I can sit up a little bit.
Okay, well, I'm just concerned about your slurred speech and your jerky movements there. That maybe you're under the influence of something.
Ma'am.
I want to make sure you understand what you're doing today and what's being
Yes,
said.
ma'am. Yep, I do a lot there.
Okay, are the officers still with you?
I know they came hard. I mean, but they actually I did fall asleep, but I woke up before they came in here and told me I had to hurt.
What?
All right, we're gonna go on. In 2023 CR 96.
Fuck.
Did you say the officers were still there?
No, ma'am, they're not.
Okay. In 2023 CR 80. You're charged in that case. That's one we just did.
She's taking her time on purpose, I think. Let's see if he falls asleep.
Excuse me, just a moment. I'm gonna take just a brief recess.
She's gonna have the cops go back and take a look. Everybody knows by him because he's so fucking trashed. He doesn't even know what the hell is going on. Let's see. We put some more lights out here.
All right, where did he go? Miss Gillette, do you want to unmute?
I don't know, Judge, but the officers are there outside his house still.
Well, if he were in the courthouse in this condition, I would order him to be taken into custody and tested because I don't know that he's going to remember this hearing. So he's failing to appear. Can we just have him brought into custody and tested? And then if he's still...
Damn.
Basically, I'm issuing a bench warrant for his arrest. And if they'll bring him in and get him tested. And if he's sober, they can bring him back in front of me at the courthouse. If
He
he's
ain't sober.
high,
I think we all know that.
we're gonna have to wait until he comes out of it so that he'll know, because he's got to have a meaningful reading of rights and
those lights
charges.
go?
And I just am afraid he's, like I said, not going to even remember this hearing.
So you want a bench warrant with the UA ordered?
Oh my God.
We may even need something stronger than that. We can start from you.
I'll call the officers and I'll get that done, Judge.
Thank you.
Judge, he's on the phone and he's going to try to log back in.
Okay, well, I still want him to pick him up. So you say they're outside his house, just have him wait a minute, Missy, and don't tell him they're going to come in and get him because I don't want him to bolt on him. He's just
That's
not in
fine.
any condition right now for first appearances. And he was ordered to be here.
Do you? Okay, I'm sorry. I was trying to.
I'm issuing a bench warrant for them to pick him up.
Okay. So do you want him to try to get back on or not?
No, he needs to be tested. I need to make sure he's sober enough to know what
Okay.
he's doing when we have these hearings. So, Ms. Gillette, at this time, I think we can recess these hearings until further notice.
Need me to come up to the courtroom, Judge, just have Missy get a hold of my offices. I'll stay here.
Thank you. We are in recess.
What's that noise? That's creepy. Oh my
Hello,
god.
hello, hello. This is Attorney Mike Gremlin coming to you from Chicago as usual. And we have a glorious meltdown in Judge Simpson's courtroom. The defendant really asked for it and got it. I see Colin in here. Colin, I used your clip from Judge Lal. I had a few other clips lined up. It's a short one. This is a short one, so I have a couple other clips lined up, but it ends with this glorious appearance in front of Judge Simpson. It's good times.
All right,
Let's
so I
do
need
it,
more
shall we?
glass. I need one,
Excuse me, miss.
2, 3, 4 more.
Two things. Number one, there's no gum chewing. I would love to have gum right now, but I don't, out of respect. Number two, there's to be no crop tops, no bellies showing. We're not at the club.
Could not attend. I've got the power failure signal on my microwave. This is very, very, very harsh rulings considering the events of this matter, and to just outright deny this based on a reasonable explanation of why I could not attend is extremely, extremely harsh in this case.
Well, your reasonable explanation was filed basically, or brought to the court's attention after the hearing was concluded. We had no information in advance. You're on a cell phone, have no idea why you didn't call the court, email the court, and
translation, pound sand.
Till 9:59. All right,
Because
have a nice
my
day. The case
phone
is concluded, sir.
Judge,
the case is concluded, and take me off of your email list. Do not ever send me another email, period. I can't open them. It's useless. Do not send me another email.
Don't call us. We'll call you.
You can contact the clerk's office. You may contact the clerk's office. You may file whatever you feel you need to file in response to my orders that I'm entering today. You
All right, what was the name of that? What's the name of that fucking... Ah, son of a bitch. Fuck, man, I can't remember. Spiders, that one. It's one I've watched. Is it this one? Analog horror. Someone sent me. I think that's what it was. Analog horror. I love analog horror. No. Oh my god. Is this it? Nope. Ooh, that sounds like a good one. I'm gonna watch that later. Son of a bitch. I can't remember the name of it. Let's try this. Tape 9. That's... Is that it? Oh, Briscoe Park. That's what it was. Oh, they haven't uploaded in a while. I just wanted to check on them because, boy, I still don't know what's going on in this. I just know there's shadow figures with, like, I don't know. It's a weird... Tape 24 was pretty telling, though. Dear God. 4K is... From 1080p to 4K is such a massive jump. Sometimes forget. Jesus fucking Christ. So, we have no idea what's going on. So someone makes these in Unreal Engine 5 and, or not Unreal Engine, oh my god. What's the fucking name of it? It's on the tip of my tongue, if you know what I'm talking about, yeah. And he also videotapes them. But all we know about these tapes is that Project Stargate has something to do with it. And Project Stargate was like when people were remote viewing, like they would sit in a room and they would almost go somewhere on the planet and view it in their mind and whatever. And there are shadow figures with there's these shadow figures, and he doesn't seem to be alarmed by them, but his reports sometimes say no need for a follow-up, like this one. Submission statement, no disturbances detected. Follow-up not required. But there are some shadow figures that when he sees them, he darts. Like he runs away. So obviously, there's something like some are good and some are bad. In fact, some of the shadow figures that he's seen in the forests, he's walked towards them, and they've run away from him. So I don't know what the fuck is going on. I still don't understand it. So as you can see, this is probably in a program. He videotapes some of them at certain houses, and some of them he does on whatever that program is. I forget the name of it. It starts with a B or something. I have it. I just can't think of the name. So now he's in a hospital. Why? This looks real. This videotape right here. But you never know, huh? Blender. Some of them are in Blender. I'll try to see if there's a shadow figure. I'll try and catch it for you. You'll see the little eyes peeking. Sometimes you can see them peeking in the door or window or something. Something to do with birds too, because he seems to follow the birds for some weird reason. That's weird. That bathroom looks pretty newish. I think this is in Blender. No? Is that something in that doorway? Nope. Peoples of Bombay. Okay, so here they look like they're in karate uniforms. Huh. Interesting. My own story. I haven't caught anything yet. Whoa! What the fuck was going on there? What happened that? What the hell? What's with all the red? What the fuck? So I'm guessing that was like a part of another tape. Uh-oh. Oh, okay. I thought he was going... He was walking fast. What? Was someone looking around that corner? I swear I saw someone looking around that corner. Nope. No. Oh my God. Sometimes you just gotta, like right there. That looks like someone in the window. Or maybe not. I don't know. Oh, there's that red again. I don't know how this guy does it, man. And why he runs after these shadow things. One house he walked into and the chair was rocking back and forth and didn't bother him. Alright, so 30 minutes of found footage. So these are probably all the tapes in order. There's a blood moon. We noticed that there's a blood moon every time he goes out, or like some of the nights he goes out. But these houses are always sitting out in the middle of nowhere. Like, there's nothing around it. It's just a house. Which is weird in itself. There's that blood moon. So that's obviously important to him. He's looking for tapes 4 through 9. He's obviously looking for something. Like I said, he doesn't get scared by these things. There's only like a few that he's obviously terrified of. Don't know the difference between them. One of them screamed at him. There's also another video of it looks like an old woman standing there, and he ran from her. See that bird? He'll follow it. Oh, maybe not. Rats. I think he walks away from this one. You hear that? Dude, didn't even fucking phase him. Didn't even phase him. You see that? There's obviously a huge gust of wind. Followed by footsteps coming up the stairs, and he just kind of, okay, and then just walked away. Weird. Like, was he grabbing it to leave with it? So I also know there's a little girl that I can't remember if he like went into a labyrinth type house and the only way he got out was from the little girl giving him directions. Oh, okay, never mind. Well, this isn't. Well, it's still out in the middle of nowhere. Whoop, I saw some eyes. Oh, maybe it was just. He's going into that church. Anyway, I'm gonna go. If anyone want me to go over these tomorrow, I'd love to go over these. I love this kind of stuff, dissecting these videos, and yeah, he does a really good job. I wonder if I can see that one. I'll just there's that. Yeah, that's the one where he was like stuck in some labyrinth in some house. I'll show you the one where that thing yells, screams. It's out in the forest. It's fucking terrifying. I mean, it would be for me. And that's the one with that. Here, I'll show you. Well. Oh, is that it? Yep, that's the one right here. Alright, if you look. Okay, the audio doesn't work. See that black thing right there? Yep, it's right here. Standing up there. This one kind of fucked me up. Oh, that's the church one. Yeah, that's the... Where's the church one where it's like, almost looks like... Blood Moon. Oh, that's the one with that little... That girl just standing out in the field. That's the only time you see a person. She's in a hospital gown, it seems like. There's that thing over here. Come on, get rid of the... Oh, okay, never mind. That's a grave. Or something. Are those TVs in there? Or graves? Okay, I was gonna say if those are TVs, that would be the remote viewing, maybe. Oh, here's a. Darn. Oh, that's the one right here, tape 9. The one I'm looking for. Walks into a house. It's all fully furnished. Then you see this happen. See that chair? Oh, wait. Maybe it's not that one. Here it is. Hear the chair? No? What the fuck? Oh, it's right here. Because he jets out of there once he sees it. See? Oh, and here's that. Seems to be something standing there. Yep, and it looks like it's coming towards him. Yep, it's right there. And as soon as he sees that, I mean, we're super close. He starts running. And then he comes up here to some fucking house. Just a random house. I don't get it. I still don't understand the series. I just don't get it. Anyways, okay. I'm out of here. Found footage. Found footage, analog, whatever you want to call it. I love it. Ugh. See you tomorrow, Wolf. See ya. I'll be back tomorrow.